The reason is that tomorrow we have tomorrow.
Maybe, but when that has happened long back, you are coming overnight.
This time is the last.
When that has happened?
This time only said, that's it.
That's right, but not in the contingent of this happened, he should have told me immediately.
There was no problem in the transfer. But now they.
You manage nothing is going to happen.
He said that he will.
Just arguing to mention, Your Lordship, CRLMC number 2665 of 2024. This is a very urgent matter, Your Lordship, because I would like to bring to your court's attention. A case was registered under Section 302 murder case. A 22-year-old girl's dead body was found from the power channel of the land. Severe investigation, Your Lordship. Urgent matter, it was supposed to be
Urgent.
But immediately section was registered against the accused persons, but they were later without being committed to the magistrate court. Your Lordship, what is this?
I don't understand.
The accused father was working as a joint secretary at the Home Department. The police has not yet submitted this charge of 1.5 years to the incident. Your Lordship.
When the FIR was registered?
FIR was registered on 1st March 2024.
When we are in 24.
Yes, we are in 24. It has been no, Your Lordship. The Honorable Justice Aditya Kumar Mahapatra sir also had taken the serious note of it. The state had filed its counter affidavit on 19th of September. The Honorable Justice Aditya sir also asked. I'm sorry, Your Lordship. Honorable Justice had also asked the State Council as to how this case will go to the CBI. They had said that it's an executive. It was on 6th of November.
Also. Then judgment also. This is no way of saying like this. You please try to, you are young, very young, and you, out of excitement you are saying all the things, right? But while mentioning, you should be very careful.
I'm extremely sorry, Your Lordship. Extremely sorry.
Pardon.
Yes. Accused. Accused.
You are the accused. What happened?
Finally, as a demanded by the lower court, so I pray to implement of this common government resolution.
How much time it was that? 29.
This one.
Keep it on 28.
I don't remember.
But once CRLMC updated on 2024, I'm filing this memo for withdrawal. If there is some defect in the petition matter, I want to withdraw and file it afresh.
Withdraw.
Lordship, this tomorrow is.
Yes, madam. Tomorrow.
Madam Lordship, this procedure posted today, Lordship. Thus, the elections of is not listed. Interim order G till today, Lordship.
Interim order?
Till today.
It was no interim order is passed till giving the date. Never. Till next date of hearing.
It is posted today, Lordship, but it is not listed.
Oh, that's a different story. But the interim order expires today. Don't see that. Because it's always interim orders are till next date of hearing. If matter is not listed, whenever it is, that will go on. And leave it, we'll see.
It's the government servant.
It's all right.
Isn't it, Lordship?
I will mention there is a CRLMC wherein the order of cognizance is challenged, wherein the cognizance is taken.
Whatever I have already told the press matter, don't mention it will come in serial. Not going to it will be like this.
After this matter.
After this it will come. Don't worry. Wait. It will come. Please give some breathing space. It will come.
Definitely. Pardon my lord. It tied up. I have filed an interim bail application.
All bail applications
your lordship has granted in one case interim bail. And the matter which has laterally my number that has been also listed. My number is 9997.
Give it to me. All matter will be listed.
Interim bail has granted in one case bail. This one court has granted, but in another case he has been in the transportation. The petitioner is accused in two cases. In one case, interim bail has been granted. Okay. Another case is there. Chronological the matter has also not been listed. Another compromise matter.
Press admission, please don't mention it will come in serial. It will come, don't worry.
Pardon the mention.
Compromise. Offense? First decide the offense, tomorrow. Decide the offense, what offense you have committed.
It is sharing after notice. Sharing after notice. Vacation.
Don't mention fresh matters, it will come serially.
Criminal appeal of the year 2014 CBI.
Appeals will be introduced. What is happening? Weekly escape.
I may be pardon to make a small mention, my lord. Page mention, this is item number 22. My lord, the matter is amicably settled, so may I pray that the matter be taken up at offense number 376. The covered by your worship's judgment, my lord.
Also, you also there.
Okay, sir. My lord, both the parties are present.
I'll take it up while you.
Because so I don't know if
It should be covered, otherwise,
it is covered, my lord. They are married.
Item 65 compromise matter both parties are present here. 506 offense 36. Earlier as notice has been issued. Person that notice they were
6 item,
65.
2 o'clock. 2 o'clock.
55.
2 o'clock. All settlement matters 2 o'clock will take. Okay, no problem.
55 years में कहानी पे taken up 2 PM. 55 years.
Yes, 1 minute.
Already married.
55 years. Item 8 matter.
Yes,
Item 8.
Item 50 years से compromise में taken up 2 PM years.
Yes, we've done it.
Did
Pardon the
you?
mention, my lord.
Item 8 by law. Permitted to withdraw in order to file better. I have filed memo. Withdraw. In order to file better application, we have filed better. What are the offenses? Huh? You don't know what is the offense and you want to settle. But he confirm. Learned counsel for the petition counsel for the petition submits that there is for settlement in this matter and he seeks 2 weeks adjournment. Leaves the matter after 2 weeks.
Item 3, for adjournment lords. Item 3 lords. And for the petition lords.
Okay.
Pardon the mention, my lord. Pardon the mention, my lord. 498. Compromise is settled between the parties, my lord. There is a case number 320.
You complete the sentence, no? It is 498. What is
court in CRM's number 382.
What do you want, sir? You tell.
The matter is settled with tomorrow, my lord.
Is it fresh matter? Matter has already been settled. 498.
My lord.
You want to see it? Okay. Complete the sentence.
498.
498. Okay. It's all.
Yes, my lord.
Before the vacation is listed.
What do you want?
Maybe next week anyway.
It will come in the weekly list. Get ready.
Weekly list already not listed. That is my idea.
It will be taken. We include the weekly list.
I don't have.
This matters relevance. Passing of the proceeding, principal accused has already been died, and the wife of the principal accused, who is the proceeding once 100.
Passing of what?
Passing of the proceeding, 109 proceeding.
How the after the accused is died, then his wife wants to do it. Why? How it is maintainable?
That is my question.
It's not maintainable. Only in case of conviction you can carry on. You are not convicted. He died, then everything ends up.
Proceeding issue to the someone to.
Why?
Mercy. 100.
Item 5 kindly permitted to withdraw.
5?
Item 5 permitted to withdraw.
Yes. Withdraw. 6 also withdraw.
53 after versus to Mishra and praying for a short adjournment because I have sought for instruction regarding present status of the case, madam.
53, yeah?
Item 53. Madam, next week only the continuing.
Next week, don't ask for next week. 2018 matter.
No, no,
He is operating.
no, I will only sought for the present status of the case, my lord. Because the advocate concerned has already, lower court advocate has expired, therefore we have communication gap petitioner. Next week,
Next week.
Yeah.
Why is you service? Service is also awaited. Report is called from IIT Dharamnagar PS.
No, that is the nothing one.
Next week, let's follow that.
My lords, vigilance criminal appeal. Pending for final disposal. It's a conviction, challenging the conviction. We'll try to take it up any day next week in the supplementary list.
Not supplementary. Why? Why preference?
My lords, urgency is there. It's a matter. 2018 matter.
So that it will be included in the weekly list. Include the weekly list, yes. Yes. But if the prayer is given to decrease the account, stands in the name of the farm matter of the petitioner. Sorry? Then with decrease the account, farm's account matter, which was proved by the IO in course of the investigation of the case matter which was by the Mr. Rohan Miller. The case was registered Miller. Similar spurious drugs Miller. Spurious drugs Miller says Miller 10 What is this implemented one 457 petition was filed before the London trial court. An application on the social court petition was the Honorable London trial court, which was rejected by administered by the administrative. Yes. Then the petitioner made an application in the social court to the submitted by the administrative, and the order is at page 27. This court has granted liberty to the petition from the revision petition before the London divisional court. Yes. So the revision petition has been before the second additional sessions. It is now rejected. It was rejected. That you have come. Yes. Against this method, I have prepared this policy too, with the prayer to decrease the farm's account. And another submission to make this under two petitions was in the two fatal publication as filed. One was the previous petitioner, another one Chanchan Jalan, because several applications submitted, several efforts was done during that time for selling of that particular. They say they are asking for defreezing of an account. Yes. Why are you going round and round? You say some defreezing of the account, you are an accused. I am an accused. First application was rejected by the magistrate and you went file revision also rejected, therefore you are here. First application rejected, thereafter I know you gave High Court straight away, High Court said that file revision, you filed revision, which is rejected. Yes. Against that you have come. Yes. Also, you are an accused. I am an accused. You are an accused. You want a defreeze of two accounts. Two accounts. Yes. I just issue notice on this. Check it out. Yes. Issue notice. Yes. Yes.
Item 2.
Yes. Who is asking us? Let's take the party minute. I will serve a copy on. Yes, yes. Item 2.
Item 2.
Item 2. Password.
Item 4.
Yes.
Very short question. What had happened, my lord? A witness was examined
Yes.
as PW2. The Lund PP allowed him to adduce evidence in the doc by holding the original record. I objected it. The petition. That application has been rejected. Against that I have come. Only 159 Evidence Act will be examined here.
5324. Let us see what.
Only 159 of Evidence Act will be examined here. Let my friend be ready on that aspect so that you let me fix up a date. What is the role and what is the.
No, what is your application?
Here I can dispose of that. Small matter dispose.
कौन करो डिस्पोज कर दो अरे 159 में फिर एग्जाम करे तो क्या ना बड़े विटनेस को allow करना
What was your view on this?
so if मतलब re-examination don't allow a witness to hold brief and make a statement before the court.
The entire brief was given to the complainant
Yes,
Information.
and for refreshing the memory.
Memory.
repress of memory prior to that.
While if somebody, where have you said that while deposing he was holding the file?
Entire case is that you also can see that from the very beginning also,
This was
very beginning also order, from the order itself.
complainant should be treated as a witness and should not be allowed to see the case.
Para two, let's say.
While deposing.
Para
While, yes, while deposing.
Yes.
While deposing, he should not be allowed to send it. Yes. For this reason, what do you want now? Evidence has come on record.
Chief, chief, he has to.
No, I have not cross-examined him. I filed a petition. I filed a petition and I said after disposal of my examination, I'll examine the witness. Now that application has been rejected.
What do you want now?
Now, Lordship, allow me to
Cross-examine.
cross-examination, there is no difficulty.
Then
There is no difficulties. But whatever
your objection is recorded. That will be taken up in the final stage.
Final stage.
no, that has not been recorded.
I'll record that.
Yes, that
That objection may be taken on record.
Yes.
And you will be allowed to cross-examine.
Exactly.
And the final stage that you will be paid.
And also
Never evidence will be decided.
one scope of 159, a person,
Everything is kept open to be decided at the final stage.
no, my lord,
What is the worth of the evidence of the complainant?
yes.
That will be decided at the final stage. You may say that this should be taken off the record. It cannot be relied upon
Correct.
because of 159 whatever.
Correct.
Because you have taken, rightly you have taken non-objection.
Correct.
And that objection has to be recorded in the evidence itself.
Instead
And what
of,
of the evidence will be decided.
instead of recording my objection, you file, my lord, court will directly file a petition, I will deal with that order, deal with the,
And then you rejected it.
and in the meantime, examination is over.
Rather what I'll say is, the application which has been disposed of, I will set aside this and I'll keep it open to be decided at the final stage. That's a better idea.
Yeah, but, yes,
This order I'll set aside.
Correct.
This order I'll set aside, allow you to cross-examine and the application which you moved by way of an objection. Decided at the
instead of
final
the
stage.
time, yes, it is manner.
That is fair enough.
Yes, yes.
Isn't it? Fair enough.
Yes, yes, yes.
Fair enough. Because the worth of the evidence of the complainant will be decided by the court at the final stage.
Correct, correct.
Final stage. I know. The petitioner has petitioner is accused in so case. While the evidence of the complainant was recorded, the petitioner being an accused has objected, had recorded an objection, objected and moved an application under section 159 of Evidence Act. The petitioner petitioner requested the court below to record his objection, because at the time of recording of evidence, the entire the additional PP had handed over the entire record to the complainant, and complainant while deposing has repeatedly referred the record. At that stage, when the objection was raised by petitioner accused, the court asked him to move appropriate application. And therefore, he moved an application under section 159 of Evidence Act. By way of the impugn order dated 5/3/2024, the said application has been rejected. And Counsel Mr. Pradhan and Counsel for the petitioner submits that neither his objection was recorded, nor he was allowed to cross-examine the said complaint. I have perused the I heard the Mr. Pradhan at length, and Mr. Arora for the state Mr. Arora for the state. Perused the order. I am of the considered view that the trial court ought to have kept the objection, record the objection raised by the petitioner accused, and kept it open for the to decide at the final stage regarding the said objection, instead of deciding by inviting an application. Therefore, the impugn order is set aside, and the objection raised by the petitioner accused to the objection raised by the petitioner accused may be taken record to be decided at the final stage. Petitioner is at liberty to subject the complaint to cross-examine on the date to be fixed by the trial court. The trial court is directed to decide the objection raised by the petitioner at the final stage without being influenced by the observation made by the trial court in the impugn order dated 5/3/2024.
In fact, my lord, master deal with that aspect, my lord. Paragraph 11. 11, next page, my lord.
Yes.
In the decision reported in 1980 Criminal Law Journal, in the matter of Islam versus State, the honorable lordships of Allowed High Court had a deal with the matter and had
No, you say that
that aspect I am coming, my lord. Memory referring to the honorable court held that the informant would have replaced his memory by seeing the first report which was lost by him. Even if so far, if the PP wants to, my lord, put a question whether this is your signature or this is your that can be sworn, my lord.
but he can't hold it and read it out.
I can hold, my lord, but he.
There is a difference. That is why the trial court
Exactly.
That is 160. That is 160 evidence act.
without draft out putting the law. Draft out 5 steps.
No, you go.
Okay.
Well, let me observe that. Again, the magistrate, if will allow examination by this manner, accused person will be
But I'll observe. This is a draft out only.
Yes.
Yes.
Item 7.
May I please action? The petitioner before lordship, they are a husband and wife. They have challenged the order of ordinance on section 341, the 51st,
Yes.
and the 3 SC/ST Act.
Yes.
And my submission before lordship is twofold only. If any there that Bhajan Lal's case, even the allegations that has been taken up by the prosecution in the FIR as well as the 116 statement and all other materials, no offense is made out. Without putting it to test or taking a second thought, accepting the allegations on his face were no offense is made out, number one. Number two, submission before lordship, that the magistrate by non-application of mine has simply taken cognizance of that offense. I may invite your lordship's kind attention
Yes,
to Annex I.
yes.
At page that starts with 25, at page 27, the order of the cognizance.
Yes, I read it. Yes, I got it. You come to me now, the charge sheet. What was the allegation and 161 statement.
The lordship. May I play that order of cognizance?
I read it already.
Perfect. And then I will invite your lordship's attention first to the FIR, first information report.
We come to the straight away, come to the charge sheet at page 20. What are the allegations?
That I'll take your lordship. I will take your lordship to the FIR.
Yes,
That is lodged by the informant. So and so, son of so and so, all this. The relevant persons, just about 8 lines below your lordship. The relevant person. So far 354 is concerned.
yes.
I confine my submission before lordship to the year to 354 only. This informant is a real member. Hon'Ble. ଏତିକି ବେଳେ ଦଇତାରୀ ସାହୁ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ମୋ ଲୁଗାକୁ ଭିଡା ଉଠା କରି କହିଲେ
Cognizance is exactly correctly taken.
the materials should be on before taking cognizance the magistrate is obliged to take all those materials collected in the investigation so as to take cognizance.
You have
Whether there are whether there are
utterances is there, the language is
no, that is there. But with regard to 354,
therefore 354 is outraging your modesty. What else you need?
then the language,
Can you read this language in the
the idea is there in one statement of the
after investigation, the police found this.
there is no there is no other material.
There is no point,
No, there is no other material so as to sustain this line. This line to sentence in your lordship.
Yes.
So please to take cognizance. Well, absolutely there is no material. Has there been any material, any
Come to page 24.
Yeah.
Statement of the wife.
Statement of the
What she says. Same thing.
Again?
Same thing she says.
No.
Read it.
Again.
Yes.
Petitioners here challenge the 107 proceeding initiated by executive magistrate Darpan.
So
That's it. That 107 proceedings under CIP.
okay.
The petitioner number 1 is a lady and renowned poet, and petitioner number 2 is a Ayush doctor. The opposite party number 3 possibly occupied their land for which FIR was lodged at running page 25. Your lordship, Annex 4 FIR was lodged against him. But thereafter, police in a non-affair filed a report to the executive magistrate for which page your lordship.
Yes.
107 proceeding was drawn and page 16 your lordship, running page. Notice was issued to the petitioners directly to executive board. But running page 15, the audacity was written that to show cause. Section 107 says that
I therefore hereby order 107 CRPC second party to appear in the court so and so and to show cause as to why this is not the executive bond of court.
this is the order. This is page 15 is the order sheet. But page 16, next page. Next page, last line. I get the same day, that is 20th March. Same day.
You want to show cause?
So much direct bond.
Why unnecessary you are subject your client to so much? Go and give a bond and clean it up.
See the
You go and file a show cause. Once you go and file a show cause, Again, you will ask for bond. Give bond and bring it up. But law says that to law. You are subject to go to police station twice. Instead of giving a bond, go and give a bond and bring.
That's 6 months as over.
Unnecessary. Why to keep this proceeding alive?
Already 6 months are completed.
Give a bond.
Do it.
And bringing these kind of cases to the court only, you get exposed. It's better that once you get to this kind of notice, go and give a bond and finish it up. Let it die. It's not.
Law says that prior to execution of bond, notice.
You may be correct to that, and
That is why, but all but in the meantime, 6 months are completed.
simply withdraw and go. Right again. Then control the proceed. Yes.
I can tell.
My lord, on behalf of Mr. K.K. Mishra, kindly permitted to withdraw.
Withdraw. Give a memo, please. Yes.
Item 11.
Adjournment.
Why urgent, sir?
The petition is
Matter.
not very well.
December. Yes.
Item 12.
At this moment, my instructing counsel has just gone out. My lord,
You were supposed to go out.
Yeah.
You were supposed to be here.
he assists me in this because state is not a party. Accordingly, he offered his services. You are too far. You are too far. Your lordship, the opposite.
You are for
I am for the petitioner.
complaining.
No, I am for the accused in the present case. Complainant in 1cc case which I
How the
filed,
state council is briefing you then?
it's a,
If you are
it's
accused.
a complaint case.
Alleged to complaint.
Complaint case.
Yes.
Accident.
He is now relieved.
Opposite party is my lord. We are in a business relationship. I am the manufacturer. He is my agent here in Bhubaneswar,
Yes.
wholesaler. So some certain checks were issued which got bounced on deposit, and accordingly I filed a criminal proceeding in 138 Penai proceeding in Delhi court, Faridabad. That is pending. After receipt of notice,
But your sister company, Fusion Industries.
no, I am proven incidentally there is
Fusion World Food.
also not again similar here, but we are not in any way.
Both are fusion.
We are now we could not fuse ourselves.
Mhm.
So you got see that I have filed a complaint as I was stating, my lord.
Yes.
After serving of legal notice in Section 6 that is pending in Faridabad court. What number is it? 7. Huh? 7. Complaint case, page 16, my lord.
You are the accused in that complaint.
I am in the complainant there.
660
16, 16.
16. Okay.
It starts at 15.
Okay.
Court of the Ilaka, Faridabad. Your Lordship, on receipt of notice, instead of appearing there, what the petitioner, the opposite party does here, he files a complaint before the learned JMFC 1, Bhubaneswar, in 1cc case, alleging that the check issued, your Lordship must go to page 37, my lord.
Now, what have you shown me that Faridabad thing?
That is the case I have filed under 138 against the present opposite parties.
Okay.
After receipt of the notice, what he does, these opposite parties, my lord, they filed 1cc case before the Bhubaneswar court.
Where is that?
Starts at page 38, 37.
This you have filed on. When have you filed the 138?
14/9/2023.
49?
23.
No.
I had filed on page 19, my lord, of look at
22 date is not
22, February 22.
February 22.
Now, on 14/9/2000, he files a case. From the page 39, lordship, look at the events. Entire events are based on that bouncing of check.
39.
Yes, and the allegation is that I have tampered with the check.
Okay.
So if your lordship would agree with me, I'll take out notice. No interim application has been filed. short date may be fixed. So if you can sit down in the mediation and can be finalized.
That's better because it is his defense basically. His complaint here is defense there.
So that is, so the entire thing will come to a standstill. Everybody.
I issue notice yesterday.
Yes, so it's maybe short reasonable date.
Short date, 1 week after. Issue notice 1 week after.
Registered post by tomorrow.
Yes, by tomorrow you file the process so that we'll see. What is the check amount by the way?
4 lakh something. ସେ ଦେଇଥିଲା କହିଲା ଲକ୍ଷେ ସେଟାକୁ ମ୍ୟାନିପୁଲେଟ୍ କରିକି 4 ଲକ୍ଷ କରିଦେଲେ. All those defenses are there to be taken in the 138 itself.
What is the rule do?
4 lakh something.
4 lakhs. Okay.
Item 30.
Item 13 permitted to withdraw your lordship.
Yes.
14.
Item 14 are permitted. Item
Sorry?
14 my lord, 1-4.
Yes.
My permitted to withdraw my lord. 205 application, now he has been arrested and released bail.
You send a memo.
Pardon?
You send a memo through someone, huh?
My lord,
Yes.
I'll send.
Yes.
Item 60.
16 my lord, he has a case my lord, where the offences are 3 SCST Act along with my lord 32294, 323, 379, 34 all tribal magistrate. And 3 SCST Act is the ballot session tribal offence. And in the meantime, it has been subsided between the parties. My lord may fix any date next week so that the party will come and it can be sorted out.
But you have not filed anything. Investigation is going on.
Yes, my lord.
Pardon?
Investigation is still on.
Investigation my lord.
FR is 1802-2024.
Yes, investigation is on my lord.
Investigation.
Only
Simply
3 SCST.
after 2
Only
weeks.
3
Sir.
SCST.
After 2 weeks.
A date may can be fixed, my lord.
Yes. Date will be fixed. Don't worry.
Well, so that the party will come and they come.
Yes.
May pray my lord, in the meantime, I may be the petitioner may be direction may be there not to take any course of action against the petitioners in view of this.
I don't know what is the case. You have only filed an
All admitted. All my lord.
what are the offenses?
No,
You-
offences are there. 379 is the only normal offence so far the magistrate level offence are concerned and 3 SCST Act. But when see page 2 para 1.
Shall I put it next week? You bring them.
Yes, madam. Yes. That's why I pray next week, madam.
Okay, next week last article. 30th.
30th, my lord. Yes, madam. All right, oblige, madam.
17.
Please, lordship. Lordship, matter amicably settled is notice to the opposite side.
Sorry?
Matter amicably settled.
What is this matter?
Matter.
My lord, passing up a proceeding, my lord, under section 323, 325,
307 is also there.
yes, 379 is there. The
Investigation is on.
my lord, the FR is my lord 1602-2022, my lord. And now what is the status of the case, my lord? 22.
You have not filed anything except FIR.
Yes, my lord.
22 FIR. What has happened? Charge sheet has been filed.
He is saying regarding that amicable settlement. But what happened? Going on? Now,
I'm settled by
Huh? Who is your senior? You have the file with you.
senior.
Do you have the file with you? No.
Sattata, Janaranjan Saud.
Generals.
Now, where is your this file? Case file is there with you? Yes or no?
Yes.
You have done?
Yes.
I am passing over. Read it and come. I'll pass over. Huh? Read it and come. Yes.
Item 18.
You tell me whether charge sheet has been filed, investigation is completed. Something you have to tell. What are the allegations? At least you read and tell me. Then only I'll give. Read it. Sit down and read it. What is it? 12 o'clock I'll take it up. Okay.
Giving time.
Huh?
Playing for time.
No, I'll give you time, but unless you read it and tell me, I will not give. Sit down and read and 12 o'clock I'll adjourn. Okay? Read it. Yes.
18.
My lord, pass over.
18.
My lord, pass over. Pass over.
Pass over. Okay. सर आर्गुमेंट था जी पुड़िया में पूछना था कोई दिन ठीक है रिपोर्ट सर 19. 19 pass over. 20.
That's all.
20, my lord. I am here, my lord. This is my lord, where the present petitioner before my lord are the father-in-law and mother-in-law of the opposite party number, my lord, 1, my lord.
Yes.
Now, opposite party number 1, my lord, she has filed the application under 12 of the DB Act before the concerned court of my lord, JMFC, my lord, Konark, wherein now she has a complaint that her husband has neglected, and by the process, my lord, she is entitled for certain relief under the Domestic Violence Act, my lord. Accordingly, the landed court has passed some order against the husband. Now that materialized, for which now she has filed application for right to residence, thereby claiming to reside in our house. That means the house of the present petitioner, who are the old person of around 94 years, my lord, to stay in our house. And that was allowed by the landed court by the order dated 25/2024. My lord, may turn to the relevant part, page 18, my lord.
Yes.
Last para, my lord. May I please, my lord?
No, but you are staying with your son also.
No. It's my specific case that son is never residing. So son is, my lord, because of some reason, my lord, she has love, because of love relationship, she is married to the opposite party, my lord. And now they are left to my house. Now she, my lord, he resided for some time happily with the his wife, the OP number 1, my lord. And thereafter, my lord, some disturbance was there. And because of that, now she has filed 498 case against the husband. That is no. Thereafter, this section 12.
No. Just see the cost title. Come to the first page.
My lord.
See the address of the petitioners. Uttarasahi, both are resident of PS Puri, Sadar District Puri. Okay?
Yes.
Now come to the address of respondent number 2, 3, 4, and 5.
My lord.
They are also staying in the same house.
Yes, I know, my lord. It is a question to be put by my lord. My humble submission to revise and reply to my lord's query is that my lord may see the cause title of their application, and unless and until I defer say my address to the cause title, my lord, it will be defect.
The wife may not be entitled to force herself to stay in the residence of the father-in-law, mother-in-law, those who are 94 years old. You are
My
right.
lord, that's all only, my lord. And one more thing I want to. Pardon?
Husband is staying with the
Yes.
old parent.
My lord,
And she,
my
the
lord,
wife is entitled.
one more point I want to place, my lord. And when this order was passed, the present petitioner, being an intervener, because they were not heard in their presence or in their without hearing the order has been passed. So, my lord, may turn to annex number 4, page 19, my lord.
19.
Page 19, my lord. A application was filed as an intervention, or application was filed before the concerned court, praying for would set aside of the order because we have not been heard, and we may, the facts we want to present before the concerned court that the son is not residing.
I am worried about only one thing, whether the husband of this lady is fighting this case under the shadow of these old parents or not.
No, certainly not, my lord, certainly not. And my lord may see the order. When I file application for intervention, my lord may turn to page. My lord may page turn to.
I'll just issue notice, let us see. After 1 week, we'll see.
And one more submission, my lord. Kindly have a glance to annex 5, page 24. What is the order, my lord may see? Nowadays, the London magistrate has passed such order, my lord. When I filed intervention petition, now it was rejected. It was rejected in immediately.
So notice to opposite party number 1 to be with.
My lord may issue notice. My lord may issue notice. A advocate for the intervener is present. Office note is present. The IA petition is rejected. The intervener is directed to file fresh petition in proper format. What is the format, my lord? Kindly see. I have filed an intervention, adding with giving the details. Now format. In a criminal procedure, my lord, format has to be filed, my lord.
What is the big deal?
And it has been rejected.
Your application IA is rejected.
Yes.
Shall I restore your IA?
Pardon?
Shall I restore your IA?
Yes, my lord, may I pray? My lord, may I restore my IS, directing the concerned magistrate to take note of my submission, which has been reflected in my application, and will dispose of it in accordance with law. And till that disposal, the order of the land magistrate be kept in abeyance. That's all my prayer, my lord.
No, you are intervening. How can I do that? I don't.
We are not we are admittedly, my lord, we have been made in a party in the particular. So we are definitely because she has to reside in our house, and my lord may see the age. And my lord knows the consequence for if the moment she will get inside, what will the consequence? That's all the things to be considered by my lord. Yes, I don't dispute that the concerned her husband is none other than my son. I am not disputing that. But merely because he is my son at the belated stage of our life.
Okay, all right. Opposite party for two, opposite party one is the daughter-in-law of the petitioners.
My petitioners, my lord.
Petitioners are senior citizens. The opposite party number one filed a DVCMC number 47 of 2020. Where is the DV case?
That is annexure.
Annexure DV, copy of petition.
Three.
Annexure one.
Again.
Inter alia seeking the following relief. Page 10. Following relief. The opposite party number one has in the said petition, in the aforementioned petition, in the DV case, aforementioned DV case, initiated by opposite party number two, the present petitioners were not made parties. The present petitioner moved an intervention application. Intervention application being IA number 34 of 2024. 24. In the intervention application, the present petitioners have sought for the following relief, page 22. By the dated 36 the trial court rejected the failed intervention application inter alia stating agenda, page 24. Page 24. Mr. Chandler and counsel for the petitioner submits that in the impugn order is devoid of merit, and without the application of mine, the trial court rejected the application, and only on the ground that the application is not filed on the proper form. He seeks intervention of this court for restoration of instead application with the direction to the trial court to hear out the application on merits and decide the same. I am in complete agreement with the submission made by Mr. Chand. Accordingly, the prayer made by Mr. Chand is allowed, and the IA number 34 of 2024 in DVCM number 47 of 2024 is restored to its and the JMFC CORAM is directed to decide the application on its own merit within 15 days from the receipt of the present.
Pardon, 19. Just
Everything has gone.
19.
Now I am doing something else, it seems.
20, your lordship will do.
Then I can't go reverse back.
You do interluns.
You would wait, obviously.
Yes.
Follow a system.
Yes.
Yes.
Till disposal of that 15 days, the order
Therefore, I have given only 15 days.
Yes. My prayer is till disposal of that petition within 15 days, the order dated 27/6 Approval kept in abeyance. That's all, Hon'Ble.
Okay, till the application is decided, the order dated
27/6/2024, my lord.
27/6/2007 passed by the trial court may not be given effect. May not be given.
Thank you all.
I have filed this petition with a prayer to quash the affair on the ground of compromise. What happened, Your Lordship, the dispute between the husband and wife. Wife has filed 3 cases and husband has filed 1 case under Section 9 of Indian Marriage Act. All the cases have been withdrawn, but both charge sheet has not been. For that reason, we have filed this petition to quash the FIR.
Yes.
That's Your Lordship, where are they? The husband is present here. The wife is appeared through virtual mode, but she's not. Sir, I am appearing. I am appearing opposite party. Where are the other cases which has been? I am clarifying that. Your Lordship, the section, the petition which I have filed under Section 9. Again, that will when the wife received the notice, she filed a transfer petition before this honorable court. When this honorable court and the mediation, where in the record you have not placed anything except an FIR, sir. Not a single document except FIR. No, everything you are telling now. Mediation report will clarify everything. Where is that? That is there. That would have been placed on record. Divorce case, mutual 13 period. Everything is all right. Why are you holding that? You should have found it from the record. So many things you are saying, nothing is reflecting in that. And in the seeing your petition, have you said all these things? Para page 3. Page 3. 3-page petition. Yes, Your Lordship. 2 paragraphs. You do something. Why also kindly against why reducing this High Court to this so level unimaginable level? I'll file. Have you ever seen 482 petition consisting of 2 paragraphs? No. 2 paragraphs with 1 FIR. What is the friend? When you think is going on, what are the disputes? What are the allegations? That I have mentioned. You have settled the dispute. Where is the document? That mediation report, I could not able to get that, but I am supplying that mediation report. You'll also kindly have a glance to mediation report. Everything is there. The mediator element. I have given. Kindly have a glance.
4-page petition. First page is half of the cost, I think. Second page starts with the half of the page is to be most respectfully sold. Third page is the only page, one page petition.
Yes, sir. Paragraph 3. Next time this will not continue.
File a better one. I can't.
Your Lordship, kindly have a glance to the memo.
I will not. Please don't reduce the High Court to this level.
Sir, I am appearing from the.
You should have given a small sheet. Please watch the petition. Why have you written so much? One some memo you should have given. I would have let it be lie over, Your Lordship. I will amend this. Do something. Let it be lie over. I will amend this. Next week. Tomorrow you will file detailed affidavit. Bring this thing on record.
Yes, sir.
Okay. And a joint affidavit, file a joint affidavit, and bring you all this thing on record.
Next Monday, sir. Bangalore.
Okay, you file a joint affidavit, bring everything on record. I mean the small amendment is not required. Joint file affidavit, in the affidavit you say all this.
Yes, Your Lordship.
Instead of
yes, I'll do that.
Okay, Monday
next.
and henceforth please file proper petition.
It's a mistake I have done. This is never going to be repeated again, Your Lordship.
Now what the youngsters will learn from you.
This is never going to be repeated again.
Yes, next.
Wait, fine. Joint affidavit.
Yes, next. 23.
Shall I, he is asking that shall he file the Vinama in the DR?
You file on record, no problem. You file it on record. Now, along with your affidavit also you can file. How does it? Along with the affidavit, you annex that also file.
Yes.
This is challenging the order dated 28/9/2024, given Extract 2, passed by the SDM Burger, my lord, under section 129 of DNSS 2023, directed to appear in person, directed to petitioners to appear in person and file show cause on 1/10/2022, right to file should not be ordered to execute bond with the local surety. One among them must be a government surety to maintain good behavior in the locality for a period of 1 year, basing on the report of the IOC under section 129A and G of the BNSS to come. Now that BNSS to come. Well, also kindly see the 120 BNSS. Better to the color. You will see. Let's kindly see the 129. Agreed by the government security. I have not permission to know. Furnish, you are agreed by that. Agreed with also. Because you don't want to furnish government security. Not government security, totally also. Kindly see the 1G also. 129. My lord. 129A and G. BNSS.
Will I publish something?
129. Yes. But please say you mercy, each by heavy to rubber housebreaker or conjurer. The person 120 habit of rubber. Yes. Yes. Yes, 129, na? Oh my God. Yes, sir. 129, what can you see? The person be read the habit a rubber house. When an executive magistrate receives information that there within the local jurisdiction a person who is a habit of a robber, housebreaker, thief or perjurer, and G so you will also G. Which so desperate and dangerous as to render his being at large without surety hazardous to the community. This is the allegation, but these allegations are not against me, you will say. I am a social activist. The process the IOC mentioned in the report about any against me, all the cases have been registered against me because I have raised voice for the public before the arbitration, your lordship. 129 is invoked. Then 129 A and G. And very come to page 12. My lord, kindly see the page, your lordship, annexure 1, annexure 2. Annexure 2 is the order 129 BNSS upon which it is proposed to proceed G of the section 129 BNSS, your lordship. A and G. My lord. A and G. Yes. But A and G are not against me, your lordship. I am a social activist. Therefore, I pray your lordship issue notice ask whether I am a robber or have any kind of social actually. Crack. Then how I will issue notice. How issue notice? Oh, issue notice to open. But yes, stay your lordship. I will stay operation of order dated 1. What is the apparent danger to you? Nothing. No. Yes, lordship. I have the subject is done now. Yes, lordship. Something that. Simply issue notice. Yes.
24.
Please, lordship. The district petition has been rejected by the Lord Vigilance, Special Vigilance Matter. Yes. By the order dated 24/2024 under Annexure 1. 20, Annexure 1. The question is only that the offence under which the petition has been moved, that is under section 13(1)D and 13(2) of the PC Act. One question I have raised that I am not a public servant.
Therefore, this proceeding is not maintainable activity.
Yes.
You lost come to Annex 2 at page 16. I am an electrician and I was engaged by that security consultant private limited and receiving the salary from the Yes. On that ground, this Honorable Court had previously directed when I challenged the cognizance order. This Honorable Court took.
Where is the charge sheet? Where is the cognizance order? Nothing is there.
The only I have discharged the order I have given, my lord. To your lordship, that is your lordship may call for the record, my lord. That will.
At least charge sheet you should file.
That's it, my lord.
You remove an application for discharge. Where is that application?
The application.
Where is the charge sheet copy? Except the order application rejecting your application.
The order I have. Only it is available in the lower court record, my lord. Therefore,
You believe the system. Once you are charge sheeted, entire copy is given to you.
that is the my lord practice what I
Now, that not every time you file any petition and state is
that is for 37 years what I have not, my lord. That is
your petition, it is your revision petition, you have to file all documents.
if I will adapt.
Made two lines more. Now, in this case, there is a scheme known as a journalistic scheme.
Now, merit I am not considering.
Not on merit. And just 2 lines from then I've been for also notice. This value state of 2 lines have been for also notice. Well, the common notes filed an application to notice to the reports notes. But for the agro industries corporation note, the protection of work notes.
No, not good.
Yeah, made it down. And then, who was it for paper notes? And because the guy or something, thereafter the protection notes was accused of what he demanded for thereafter they agreed with the final application and the draft was made in the draft that the testimony was recorded from that notes in a draft case code. This particular petition, raising this particular issue that I am not a public servant, and this someone could already decide this particular, consider this particular proposition to formal notes, and see what is the order passed by this particular honorable in our area, page 4 notes.
I have not argued on.
Actually, come to the last line, page 4. Now, the additional standing council business for contest submits. But he does that, that he for the from the public duty, not the publisher. But that's the usual grounds. And the additional standing council business for contest submits the petitioner. Right, who is joining report to the Orissa Agri Industry Corporation, judgment and continue to perform public duty on the instruction and in the year 1915, he was entrusted with the charge of the program. And as for people, he had not only conducted inquiry but also discharged public duty prior to the incident. In that matter, he is a public servant. Having regard to the container of the charge, you can argue. It's open for him.
But he moved an application for discharge is rejected. So it should have been considered. It needs to be considered. Needs to be considered. Okay. Needs to be considered. You file the adequate documents.
Entire document, yes, my lord.
Right. For the petitioner seeks 1 week adjournment to file.
I am petition. I have not produced I have not submitted anything. Yes, you are on the arguing on merit just like a petition of council.
I thought he is helping you. He was not helping you.
Then it has been granted and in corner
Let him file additional documents.
petition the same issues.
No, that issue, the court said that at the time of framing of charge, he can argue. When he moved an application for discharge, which has been rejected. So it needs to be considered in the proceeding.
That's what I said. He's a publisher. He's working for a public concern.
Or not.
I am not a public servant.
What happened to that? His petition?
To co-accuse others.
No co-accused there.
From
No co-accused there, my lord.
It's all right.
I lost it because
Yes, next revision.
next week, my lord.
25.
Please, yes. You are aggrieved by an order refusing to release me on compulsory bail. Review default bail means I moved for release on default bail. That has been rejected.
It's interrupted orders. I'm sorry.
Yes, order
I'm sorry, it's interrupted orders.
What interrupted?
Seven staring at my learned friend.
Mr.
Sir, let me finish. Then you are at my one. 397 is staring. Now, your lordship may see the petitioner was forwarded in custody on 14/8/2024. 2024.
28, 24.
He is not a public servant.
Yes. The FIR as annexed as annexure 2, my lords may see, that has been registered under sections 13(2) read with 13(1)(a) of the PC Act and 409 IPC. And the name that was at page 11 is from Parikshit Jain, Video Suryapada block. Now, this petitioner was issued with a notice by the Vigilance IO asking him to appear for interrogation on 14th of August 2020. yes.
He accordingly appeared before that IO. The IO arrested him and forwarded him, my lords. Now, in the forwarding report, my lords, it is stated that prima facie evidence under 13(2) read with 13(1)(a) of the PC Act, 409 and 120B is established against Parikshit Jana, the public servant, Devadatta Das, the cashier, and this petitioner. Now, so far as
When the charge sheet was filed, this
charge sheet hasn't been filed.
okay. It's 14/8/2024.
My lords.
180 days.
No, 60 days.
60 days, okay. Yeah.
For me, 60 days.
Over
It was 48 months, 1410.
14 or 10, that the application you moved.
Yes, I moved the application at annexure 1. Now your lordship may look at annexure 1 at page 8. What the court writes.
Yes.
My lord may look at page 9 of the petition. Peruse the case record. It reveals from the materials on record that the accused petitioner, namely Sibo Mahanti, was produced before this court on 14/8/2024, being forwarded under section 13(2) read with 13(1)(a) of the PC Amendment Act 2018. Read with section 409/120B IPC. He is inside judicial custody since that day. Till today, he has undergone UTP period of 61 days. Case record reveals that charge sheet has not yet been submitted by the IO. And the case stands posted to 22/24 awaiting FF. One of the punishment prescribed for the offence under 409 IPC is imprisonment for life. As such, statutory period to entitle accused to get released on bail in view of 167(2) IPC is 120 days. Thus, it is clear that IO has some more time as per law to conclude investigation and to submit charge sheet against the accused persons. I have not been remanded under 409. I can never be remanded under 409. What the court writes here, lordship will do it. How can the lordship see the next on the how can I decide whether the question is made out or not made out? Against whom is 409 made out? How anything is still on? It is made out only against the public servant, banker, merchant. After investigation, we don't know what is going to happen. 120B may also come. can I be said to have committed an offense of criminal conspiracy for an offense which I cannot do?
It is a very premature stage to say.
No, it is not that
On the basis of FIR, I can't decide whether this offence is made out of.
my submission is that on the basis of the FIR only your lordship has to decide. Because at present, I cannot be charge sheeted under 409. I am a private individual, my lords. I am neither a public servant nor a merchant, factor or broker. 409 IPC, would your lordship kindly see what it means?
Yes.
Yes. Before we go to 409, your lordship may kindly see 405.
Yes.
That is criminal breach of trust. Yes. Four hundred five says, whoever being in any manner entrusted with property or with any dominion over property, dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes that property in violation of any direction of law, prescribing the mode in which such trust is to be discharged, or any legal contract expressed.
All these things I don't think I should be seeing.
My lords, if your lordship will not go into it, who will go into it?
I will go into it. It is made of.
I am not the person who is to decide the lords as to what offence an accused commits.
He has to investigate.
I don't have an opinion. I don't dispute that. Let him do it. I don't know what kind of offence is likely to come out. What offence will come out? How do you know? How do you presume things? I am not on the basis of presumption that this offence not likely to be made out. I am not presuming anything. I am only saying that in view of the fact that I am not read the fact. Yes, let us read the fact.
Read the fact.
The lordship may look at page 12.
Yes, I am.
On the allegation of misappropriation of government money of ONBADC funds of Suryapada block by Parikshit Jena OAS BDO Suryapada during financial year 2021-22, an inquiry was taken up by vigilance. During course of inquiry, correspondence were made, guidelines as well as other connected records relating to ONBADC scheme have been collected from Suryapada block. Verification of records revealed that Orissa mineral bearing areas development. What are you? I am nothing. I am a private person. No.
What are you doing?
I am a businessman. Yes. That so-and-so has been formed as a section of 25 companies on 2nd December 2014 as per directive of Honorable Supreme Court of India to undertake specific tribal welfare and area development works to ensure the growth of the mineral bearing areas. ONBADC finances projects relating to livelihood intervention, health, water supply, sanitation, education, etc. to be executed through departments like Panchayat Samiti, ITDA, Forest Department, etc. As per guidelines of the scheme, funds released would be for the specific project mentioned in the sanction order, should be exclusively spent on the project for which it is sanctioned within the stipulated time. Any unspent part of the amount would be surrendered to ONBADC unless otherwise permitted by ONBADC. Suryapada block has received grants for execution of work under the scheme. Grants received under the scheme are kept in account number such and such of Axis Bank Bhanjpur branch and number 13.
Yes. And the money has transferred to you.
Yes.
Yes.
I am not disputing that the money has been transferred.
That is the investigation. I don't know. Entrustment is there.
How can it be entrustment? When Entrustment is with the Pankaj Janani. He has transferred money to me. That doesn't make out entrustment, Millards. I don't.
This is still to be investigated. At this stage, I can't decide whether 10409 is made out or not. What offense is likely to come out and all. This is very preliminary. Well, should we say that and reject it? No, you can't decide that whether I should reject or not. I'm saying this, I will issue notice, let them file, but what order, see, you can't insist me to, I'm not insisting your worship on anything. I am only saying that I will never be covered in judgment. You, at the reading an FIR, the court should decide whether, I am not asking your worship to do that. Your worship may issue notice, let them file, what are the material which has come?
Not the outset, my lord knows
This is a final order.
this is an interlocutor order.
No, it's not. No.
The reason being what?
167(2) is rejected, and finally it is rejected. A final order where appeal doesn't lie, rule lie.
In order, application for that input order refusing to, bill application notes. This is interlocutor orders.
No, it's bail.
Honorable High Court's notes, grant refusal to grant application note.
Application of what? Application of bail.
This is an application of bail.
This is 167(2). It is neither a final
At the end
order.
of the day, this is an application. You find that was refused. No, that's the interlocutor orders. And I've been 44 Honorable High Court's judgment. That is interlocutor orders and clearly power under Sect 397(2). That is my submission.
Yes, it's all right. No problem. Then you just file reply next week and tell me the status. What are the yes. What has come? 120B, are you removing 120? Because see, in the FIR it doesn't say anything except yes, having 2 and 409. There is nothing. What are the material which has come on record? If ultimately, if you are exonerating on 409, suppose you file the charge sheet, then 167 and he's out. Therefore, what is
I understood my non-fair statute.
now the problem is, I am sorry, my lord. Now, I object to my learned friend saying that it's a strategy. I only said, raising a question of sometimes the strategy is counterproductive. Sometimes the strategy is counterproductive. What will happen is, now police will file under 409. They cannot, my lord. They cannot. They cannot, that's a different story. They cannot do it. They file the charge. They cannot. Only they about 161. They cannot do it, my lord. No, your lordship may take it from me that they will not be able to file a charge sheet under 409 and they will not file a charge sheet until Millard's 124 says then the 167 2 after 120
Is good enough.
that means if he thinks that.
Consultation for that.
I have got, I'm putting it, I'm issuing this, putting it after 1 week, you tell me the status. Yes. Okay, get the case date.
And he is going to file a reply on to.
Reply, let him, that's the.
First time I am hearing that a case of 167 2 is not revisable. In 10 matters, which I have myself moved this an application refusing to allow a bill application alone is absolutely ignorant. This is for High Court.
That's already filed.
Judgment is right. That's separate.
Let us come to the main issue. Main issue is whether 167 whether it's revision or 482, exactly. No difference. This assignment includes both the matters. I can commit it to 482 and I'll take care of your also. You file the reply. Yes. Mr. Das to file the response and file the status report regarding the investigation.
Status report.
Status. Yes. Yes. One week after. No, fourth I will not be there. Let it be seventh. Seventh, let it be seventh. Okay.
Only to place the status footnotes.
Status.
It is a matter of Belgium.
2016.
2016 years.
1000. Huh? 1000. Proper carefully. File this number for this. Maybe as a problem. Modification application. 2016 is the order.
Order.
16/5/2016. No, there is no prayer to that effect. I'll just 1,000 rupees.
I was in custody
of 15th of September. It is made clear that in the event the petitioner would not appear as per the time stipulated by this court in this order, the trial court is directed to issue process against the petitioner. Yes. You are in bail, huh?
Lordship.
When anticipatory bail?
Anticipatory.
Your date?
Date, sir, 2010. The case is from 2010.
See, 2010 case, 2016.
Lordship, I was in custody from 15 to 24. I was released this year only.
Huh?
I was in custody from 2015 to 24.
24.
Again.
In some other case.
Some other case.
That's the problem. In some other case. Then it is the state's responsibility. State should have done it. Yes.
27.
Let it counsel for the petitioner submits that the petitioner was in custody in some other case during from 2016.
2015 to
2024, during which period this NBW has been issued. Yes.
27.
Not ignorant.
Yes.
Another case में that 12/1/24 individual issue.
24 NBW.
No.
500. Huh?
Update.
You were on bail?
No. 18.
18?
18 for 18.
18 for 18.
2008.
Petition was on bail on 18. He was on bail on 7th. Thereafter under 50.
Okay.
28.
7/8/24, 13/12/18.
Sir?
7/8/24 NBW was bail in 13/12/18.
13/12.
And similar time, though I was granted anticipatory bail in the year 2000, but I couldn't avail the bail order. Police granted me bail, submitted the charge.
Anyway,
I'm on police bail, not in court.
Right on. Petitioner was on bail. Although the petitioner was granted anticipatory bail on 13/12/2018, but he had never availed the. Thereafter he might have appeared before the police.
No, police, yes, I was granted.
Bail on 13/12/2018, but for his absence from the court, NBW was issued on 7/8/2024. 500. Yes.
29.
Belgium better. 320. Sir, NBW issued. NBW issued 3/3/20. 3/3/20. 20. You are saying OPD period was 16. 15, 25, 1, 75. 16, 21, 16. Okay. 1000. Yes. 20. 22/8/2023. NBW. This one. Above 4/2023. 23. 500. Yes.
31.
31/25/215, 2/3/24. NBW 2/3/24.
NBW
2/3/24.
2/3/24. And
Reverse 25/215.
25?
25/215.
15. ठीक है 500.
32.
Released on 30 October 2019.
7/12/22.
7/12/22. Past the
22 NBW.
Miller.
You will not file anything. Hmm? 7/12. You are on bail.
Released on bill on 30th October 2019.
30/10/19.
13/10/2019. Bail. NBW issued on on
7/12/2022.
7/12/22.
Miller.
Yes. 7/12/22. Okay. 1,000.
33.
My lord, NBW from 18/10/2023.
Yes.
The bail was on 11/12/2019.
500.
34.
My lord, NBW on 25/24.
Okay.
My lord, I was granted bail in regular nature 22/2022.
By this 500. Yes.
35.
Yes.
Here my lord, offense number 302/34 IPC my lord, and thereafter turn to my lord 302/427, 435, 34 IPC my lord.
Yes.
201 is there.
Here my lord, earlier request my lordship please there.
Call for sheet. Yes.
36.
364.
It's required?
Wait a minute.
It's call for KJD. Okay. Next. Problem. 37.
Both having similar to my lord. ସେଇଆକୁ ବେସ୍ କରିକି କୋଆକିସ୍କୁ ଦିଆଯାଇଛି। ମୁଁ ସେଇଟା ବି ଆନେକ୍ସ କରିଛି।
Yes. What is the distinguishing factor in comparison to Dhaneshwar Murmu? Have you seen it?
Nothing my lord.
Have you seen it?
Only 7 witness deposition copy annexed to your file.
Including the informant. The informant is not supported. He has not said anything. In the circumstantial evidence also, nothing has come on record.
And
You have to check it.
and so also my lord, the confession statement which has been recorded by the police in presence of the witness, they have been also hostile my lord. They are my lord the
Deposition will show that all the witnesses will not supported the prosecution case.
Yes. Then he is in custody since about 2 years. About 2 years he is in custody. None of the witnesses have examined. Co-accused has been granted bail. What else?
My lord.
How many witnesses are cited by you?
My lord, that for the rejection order, the 11 witnesses have already been examined by the trial court. My lord.
None of them are supported.
No. The only deposition copy, 7 witnesses are annexed by the petitioner.
These 7 witnesses have not
Not supported, ma'am.
They are the widely witnessed.
I tell you informant
petitioner so ये इसमें है देखो फैक्ट्स है एनेक्सर 4 में allegation against the petitioner in the FIR for para 4 ले लेना एनेक्सर 4 से para 4 तक para 4 उसके बाद देखो the co-accused धनेश्वर मुर्मू filed the PL number 1026 of 2024 24. This court, while order dated 3/9/2024, enlarged him on bail. The case of the co-accused who has been enlarged on bail is in the case of the present petitioner and the co-accused who has already been granted bail is the allegation against the present petitioner and co-accused who has been granted bail are exactly the same. Exactly the same. 11 witnesses have already been examined. Out of them, all the vital witnesses, 7 number of all witnesses, those who are vital to the prosecution, have wriggled out of their earlier statement, and hence they were declared hostile to the prosecution, hostile to the prosecution. The petitioner is in custody since more than about 2 years. That is from 11/12 to 22. The present case is hinges upon circumstantial evidence. Hinges upon circumstantial evidence. The witnesses, those who have been cited by the prosecution to bring home the circumstantial evidence, have not supported the prosecution and declared hostile. Even the informant has not supported the case of the prosecution. Regard being held to the period of custody and the fact that the co-accused has already been granted bail, and none of the vital witnesses cited by the prosecution have supported the prosecution case, I'm inclined to enlarge the petition of bail according to the granted bail. Yes.
38.
Please, Your Lordship.
Yeah.
Second journey of the present petition of Lordship. The earlier days,
Not provided by my office, my lord. Somebody better.
Okay, next week.
Let us
Yes. Supply for the petition to the state council. He doesn't have the copy.
Lordship, I have supplied it. I have the memo copy, Lordship.
You please supply so that I'll take it up next week. Yes, next.
39.
Present petition, I'll approve the Sangaru Court, where bill number 2362 of 2000. It is not your.
CD, call for CD. Okay. Yes.
मैंने second time bill application my lord. Earlier my lord, I see the order my lord.
Yes.
I'll display order my lord.
Yes.
Victim exemption sorry, that is annexure 4 my lord.
Victim examine.
Annexure 4 my lord.
Annexure 4. Yes. Yes. Read it. Last in the month of Dasara, the occurrence took place inside our house. The accused being my cousin used to come to our house frequently. On the relevant date, I was feeling ill. At about 1:10 p.m., the accused came to our house. At that time, I was alone. He told me that do not know as to why I am coming to your house. I told you and I have scribed what names in my hand and showed the same to me. By saying so, all of it suddenly accused touched my breast. Out of fear, I reached the alarm. But his waist and cut me. Yes.
Page 41 my lord. Cross examination. Serial number 15. I have known the accused since
Para?
Serial number 15. 11, 12, 13, 14, 15.
I had known the accused since last 20 years back. And frequent coming to the accused to our house or with the knowledge of my family members. Oh, you are his cousin. You are the cousin brother.
Cousin brother.
Yeah, that's what the examination chief. Accused being my cousin brother.
সম্পর্কীয়
Right? Therefore, you are the brother of the prosecutor.
married lady, married lady, 36-year-old.
But this statement doesn't help you. Tell me what to do. You are in custody since?
Custody, my lord, I am since 9/11/2023,
This goes against you. The prosecutrix has said everything against you. What to do? What to do? Just find out some way out. I'll just adjourn it, read it and come. I'll complete it after 2 weeks ago. Because this, you find out some material which can help you so that I can. You are already there in custody about 1 year. You will be convicted also because of this prosecutrix. You very specifically made allegations.
law ପଢୁଥିଲା ଭଲ କଥା ହଉଥିଲା ସବୁ ଅଛି
But cousin brother, you went to his house and started physically, abusing her and kept brutally to threaten. All these things are there. He says, what can I do?
ସେଟା ଲୋକ ଦେଖିଦେଲା ମାନେ ଆଜ୍ଞା ଯୋଉ ପ୍ଲିଟା
What can I do? Cross examination also nothing. You could not elucidate anything.
18-20-22
And what are you reading? You are reading that I know the accused since last 20 years. Obviously, because the cousin brother is known to you. Find out one particular sentence from somewhere so that I can help you out. You read it out. You read it out. Don't hurriedly do it. Don't hurriedly do it. Yes.
41.
21 million, I had the instruction to take it from next week.
Okay. On request, adjourn. Yes.
29.
Yes.
42.
May I regular signature
Yes.
conferring more than 1 year. 9/8/2023.
98.
2023.
Wait. Let us go. System.
At the bottom, it
Give it to him. Okay. Case judge. Call for case judge next week. Yes.
53.
May I please? It's a review question, my lord. I need to satisfy your lordship that after the exhaustion of SLT, this matter is being filed. My lord, the SLT was not entertained at all. I am supported by a judgment of the Hon'Ble High Court. Not only one judgment, there are several judgments. In fact, it starts all Punya Ahmad versus State of Karnataka on 2000.
Where is the main order?
Main order is at the main order page 43.
43.
Page 43.
Against which you have, the order dated 8/2/2024.
8/2/2024 is page 44, 43 it starts, 44, page 44. Actually, the only grievance is that one of my vital point has not been adjudicated so far. In fact, it was before the first appellate court itself. I filed an application under order 41/27 that the additional evidence is need to be taken on record, but that was ordered that, okay, it will be decided at the time of final hearing. If a lordship kindly come to page 27, that was the order passed by the first appellate court only.
27.
Page 27.
Yes.
Page 20. In fact, I filed an application, then another application.
No, this is a review petition.
This is review petition.
Under order 47, whether you are covered or not, just tell me. Apparent order, what is the apparent order?
Apparent order that before the first appellate court, I filed an application under order 41/27, giving additional evidence that, in fact, let me go back to the main brief. This is a case, Mamu Hon'Ble between ଅଜାଙ୍କର ଗୋଟେ ପୁଅ ଗୋଟେ ଝିଅ, ଝିଅର ପୁଅ half of the property, one of the property Oja exchanged with me. Half of the property remained and I purchased that property subsequently. After demise of Oja, Mamu came forward saying that, that was not, that is a sham transaction. There is no, it is a registered sale deed.
Again on merit.
No, I'm coming to that. It's a registered sale deed. Then he filed a suit for possession and suit for cancellation of sale deed. In that cancellation of sale deed, in the meantime, I sold out half of my property for construction of building on that particular area.
Yes.
Then the suit was filed against me by Mamu. Then I kept, he filed a certified copy of the sale deed also. The trial court decreed partially the matter. No, it is not that you are a co-personer of the property. It is a self-acquired property by his father, and self-acquired property, so he can sell it. And so far as your co-personality right is concerned, it is between your mother as well as you. Both of you are entitled for this. Now, after the decree was passed, decree was passed against me on the ground that I could not show the original sale deed. Original sale deed, actually, I was under the impression that, okay, he filed the certified copy of the sale deed and that was adjudicated by the trial court. Merely because I could not file the original sale deed, it was misplaced somewhere. So I moved an application before the first appellate court, and that application is, along with my application for bringing on record of the certified copy of the sale deed, I also moved another application summoning the sub-registrar and the record of the sub-registrar. Both the applications I have filed before the first appellate court. And the first appellate court at page 27 pleased to order that, okay, your application is there, but we will decide it at the time of hearing of the appeal on merits at the final hearing, page 27.
Yes.
Then when the final order was passed, there is not even whisper about that because the bench was changed or something. The honorable judge was not there, third additional judge was not there. So another judge passed this order and there is no whisper. Again, in the second appeal, I have agitated the same issue. One of my most vital ground is that my order 41, rule 27 is not adjudicated so far. That was also there. Even in the second appeal also, that was not taken care of. There is not even a whisper of that. My ground is there. I have quoted that ground. I have the para 10 specifically says, my pleadings says that I have got a it is not been adjudicated. My application has not been adjudicated. When I went before the Honorable Supreme Court said, okay, you go before the High Court, but it has not recorded accordingly. It has not recorded specifically, but say that, okay, you agitate this. So 4127 has not been, because it is only, and now the executing court, instead of, because the decree is there that co-person right, and my mother and my brother of my mother is also, both are co-personer in the same property, having equal right. But now entire thing is in execution court, entire thing is given to is going to be given. It is not finally given, but yesterday it was listed, again today it is listed, and I have moved an application for stay also till adjudication. Related notice we issued to them, because please see this.
Where is the apparent error?
Error, this mine.
None deciding your application under order 41 rule 27 in the first appeal.
Yes,
can it be error apparent on record in a second appeal?
Because
when in the absence of substantial question of law under section 100, not framed. Show me the substantial question of law under section 100.
First,
I could have understand if had it been a first appeal arising out of a first appeal proceeding. First appeal you lost.
First appeal
and second appeal you came. And there is no substantial question of law under section 100. And second appeal is disallowed. And thereafter you went to the Supreme Court and dismissed. And now you file a review saying that apparent error in the second appeal. How is it manageable?
Please come to page 3. Please come to page 3.
Okay.
I've said so. Please come to page 3. My pleading is there.
Yes.
This were in the RSA. Before,
yes.
Please come to just 7-8 lines from the top.
Yes.
Challenging the said order. RFA. Before that also I can say just However, the said application never saw the light of the day in the final order passed in the RFA. There is not even a slightest whisper about the said application on Order 41 Rule 27. Challenging the said order before the Honorable Court in RSA number 217 of 2023, the petition, while clearly pleaded aforesaid aspect at part 10 of the Mamla appeal, had also taken the following ground at ground D. For that, the lower first.
Actually, you show me the substantial question of law.
Substantial question of law, it is not there. The
second appeal.
Our second appeal is not there with me at this moment, but the order is there. In the order also, the order is there. Yes, please, page come to page 49. 49.
Yes.
Para 8. The appeals have been admitted to answer the following substances. Whether execution of sale deed under Exhibit 4 has been duly satisfied.
And where there is no substantial question to that effect. And where have you argued about 4127?
That has not been recorded. It was, I don't know, where have you argued? How will I know? That's why I say, page 3.
The ground you might have taken. Ground doesn't mean that
I did argue, my lord. This judgment was resolved and it was passed after subsequently. Please see, the judgment was resolved
when the substantial question for law was framed.
49, para 8.
No, then when was framed? At the time of admission,
on the very first day.
Why have you not raised that 4127 is not considered?
Page 44, please see, page 44, the date of hearing was 1st February 2024 and judgment was reserved and the date of the 8th February.
No, at the time of admission of the appeal, second appeal, substantial question of law might have been framed under section 100.
This is this.
And this is the only substantial question of law in self-acquired property or ancestral property.
No, it's not self-acquired. It says para 8.
Yes.
Whether execution of sale deed under Exhibit 4 has been duly satisfied in respect of suit property in favor of dependent number 1.
That's what the court says, that whether it is the ancestral property or self-acquired property. And ultimately, court says that it is
this stood finally from the day one. Even in the decree, it will not see. That
I understand. The only question which you are raising is that when the first appeal was pending, I moved an application under section 4127, saying that some additional evidence is required to be taken up.
No, actually,
and the court says, first appeal court says that in the final stage it will be decided.
Before that, let me hear. One second. Kindly come to page 33. Kindly come.
33.
This is RFA order. Page 33. In fact, it starts from 32. What RFA says.
Yes.
It is in view of the rival pleading, the learned trial court in judgment dated 6th September 2014 observed that the suit scheduled property is not ancestral property. This is declared finality, but the self-acquired property. Further, the plaintiff has objected due execution of the registered sale deed and its genuineness for which he has to prove the alleged importunation. But that is only when the defendant have to prove due execution of genuineness of the disputed sale transaction. Here, the defendants have not produced the original sale deed. It's only the question of original sale deed. DW1 did not speak regarding the execution of impugned sale deed. Radhamohan Patra not pleaded proved any justification for not filing the original sale deed. Hence, in the absence of original document on the basis of secondary document, the genuineness of the sale transaction cannot be ascertained, for which defendant failed to prove the execution of genuineness in view of the Rangman's case, Subramanian Mukherjee's case. Next, the Radhamohan was the owner after him. It devolved upon the plaintiff and defendant number 6, for which plaintiff is the co-owner.
Yes.
Accordingly, the learned trial court answered the issue and decreed the suit property on contest against the defendant number 1 and ex parte against the rest and directed defendant 2, 3, 2. Being agreed, then I filed this on ground that no issue were made on 30th of April and if not signed by PO, for which judgment is liable to set. The trial court has not maintained uniformity with regard to the document and no finding have been made with respect to other document except document number 748.
Come to 47.
47. Page 47, madam.
Order 47.
Order 47.
You tell me, you covered by what? Which provision? Order 47, which rule?
Order 47 Court of Civil Procedure gives.
You're covered by which rule?
Madam. Under sufficient.
My jurisdiction is confined to order 47.
Yes, madam.
You have to satisfy me under which rule? Under order 47.
Then
your case is covered.
There is discovery of document.
What discovery of document? You don't have to give discovery of document.
Please.
Document was in existence. You moved an application under order 41 rules 27. And at the first appeal it stays.
No.
Then why? How are you saying it is discovery of document? It is a concurrent finding rather.
Just please see last one application. Please see what is my application about. That order 41 rule 27.
Where is that?
At page, the relevant para is at page 14, para 3.
40?
Yes, ma'am. Page
40.
14.
14. Yes.
This is all description.
Yes. Yes.
Yes, madam. Page 16, it is operative proceedings, page 16 in fact. No, in page 17, para 8.
17.
Page 17, para 8.
Yes.
The applicant could not produce the original registered sale deed bearing number so and so into court as it was misplaced by mistake in inadvertence. The defendant number 1 and 2 searched for it before trial and could not get it, and so it could not be filed at the time of trial. And defendant 1 and 2 could not file the certified copy of the sale registered sale deed as the defendant number were under the.
When you got that sale deed?
During the first appeal. And I wanted to produce that. Please see, next part. We are under the impression that plaintiff already filed certified copy. We were under the certified copy he has filed. So what is the then no mistake? It was not even with me. Consider the certified copy is sale deed.
So show me the first appeal order.
Yes, ma'am.
What does it read? Deal with your order 41?
Page 27.
27. 7.
Yes, madam. This is order dated 4th May 2002.
That I have seen it.
Yes, ma'am.
The first appeal decree, the first appeal final judgment, you show me.
Final judgment, there is no whisper about this. Actually, this clearly says that it is already stated to hear the two petitions dated 13/11/2017. 13/11/2017, my lord, kindly see these two applications before the first appellate court. I got that after during the first appeal. I said, okay, this original sale deed is here. Please see. And that was.
Why have you not filed review against the first appeal?
No,
discovery has taken place at that stage.
Yes.
Review should have been filed against the first appeal order.
Instead,
because discovery for the original document which you lost. Therefore, you moved an application under order 41 rule 27.
Yes, ma'am.
Saying that I discovered this document.
Yes.
So please consider this document. That was not considered. So the review would have been, you had a cause of action to file a review against the first appeal order.
Yes.
You didn't file the review. You went to the second appeal.
Second appeal.
And there is no substantial question of law.
No, second.
You should have insisted for second. Why have you not insisted for question of law? In the face of two discoveries. Where is the question of law, sir?
Please see. Let's read the.
I try to find out way. I'm not getting any way out.
See, please see the.
And SLP is now dismissed.
No. Please see the question of law again. Please see.
I have seen it.
No, that is not ancestral or anything. Please see the question.
Where is the question of law regarding a discovery of a document and the face of the application being rejected under 4127? It needs to be considered at the stage of second appeal. Where is that?
This is
you have a good case. Had it been at the stage of the first appeal. Now you are holding a document.
Yes.
Which unfortunately could not be brought on record. You attempted at the first appeal stage. First appellate court says that yes, at the final stage it will be considered.
Yes.
If they don't consider, then therefore you should have filed a review petition there, saying that under 47 I am covered.
I agitated this in the second appeal. I'm sorry.
What agitated?
I give a ground specific pleading to that effect. Please see. Please read the question of law.
I read it.
Whether execution of
It takes seconds to do it. Don't worry. You have a very hard case.
Can I, if your lordship, then can I suggesting remove it for the RFA again now? Remove it for the RFA.
I can't, after the SLP is dismissed, I can't.
That is, that I am covered.
SLP, I am covered. No, that everybody knows that judgment. Dismissal is not a judgment. I know that. That's
And,
not.
and I was suggesting that there is no specific, but the Honorable Supreme Court also said, okay.
I only can say that you want to withdraw this petition to resort to the remedy available under law. Beyond that, I can't say anything.
And the entire thing will go out.
I'll record your statement and that too, I'll record your statement. I will not give the liberty. Because you don't have a case.
Instead of.
One
last indulgence. If remedy available under law, instead of that, can I move it?
No, many remedy available under law, you know that. You can, even if you can file a suit for declaration seeking the second appeal judgment to be nullity under law if it is obtained by fraud. Many remedies.
This will. Civil law. Today we are exhausted. Entire thing will be.
When Chitrapati and counsel for the petitioner seeks to withdraw this petition to resort to the remedy available to the parties under law, dismisses withdraw. Yes.
My lord,
you tried hard.
first I will merge with the second appeal, my lord. If you lordship kindly just can be some.
Leave it there, right?
One small. Can the execution court, because they are going to finish it up today itself. Can the execution.
While not entertaining the review petition, after SLP is dismissed, I will state execution proceeding.
No, not execution. Available and some protection may be given.
See, getting a degree, you know, easy, but executing it is very difficult. You have order 20 and rule 99 onwards. Read it and do whatever you want.
Some protection.
You read order 21 is the biggest order in the CPC. You can embrace it anywhere. Yes.
Flash.
Yes.
Yes. Under section 294, 323, 242, 7, 109, 376, 2N, 34 IPC and DP Act, section 5 and 6 of Orissa Prevention of Witch Hunting Act.
So could you hear yourself? Whatever you have shared, you could hear yourself. Tell me louder. Yes. What do you want?
Passing of criminal proceeding. Yes.
Yes.
And 198, 376.
Is it 34?
Yes. What do you want to say? Have you prepared it or not? You're not prepared, it seems. You want time for preparation?
Arjun.
Huh?
Arjun.
You have not prepared, ask for time. Okay. Put it up to 2 weeks. Prepare and come. Okay. Yes.
45.
Yes. May I please, last occasion, given last chance to the IO to produce the information.
Last time, last order, my lord, I also appeared through VC, my lord, but the opposite two not appeared. He had went somewhere else, my lord, and he asked for time. Same thing, my lord, notice absent.
Somebody sufficient because I was served the notice to the
I was also served the notice.
Yes.
I also appeared last time, appeared, my lord.
Yes.
May I please, Joseph?
Yes, served the opposite party, IIC so and so. In court of mutual mode submits that he has already served the opposite party number 2 and informed her regarding the date of hearing of this case, and however the opposite party number 2 has requested through him for an adjournment in this case.
Yesterday evening, my lord, I contacted the IO, my lord. IO somewhere else for the purpose of investigation to Barumpur.
No. I have served the opposite party. Opposite party said that one adjournment you please manage and come. Adjournment was granted. Now matter is listed.
Yesterday also, I also contacted the IO, intimate her regarding the case is posted today.
What is this case intentionally avoiding the court? So, first of all, in the year 2012, she lost an FIR against all the in-laws against husband, and a compromise made. That is at page 26 annexure 3.
26?
On page 26 annexure 3. Yes, so compromise was made before the IOC Kunturi.
Yes.
In the year 2012. Thereafter, she took all the household articles in presence of the village agent.
What is the mental status?
Yeah, already expected divorce from the
What is it? We can't wait for that. Good question.
Yes, yes.
Question. I know. Where is the expected degree?
That is annexure 5 years.
Notice was issued to opposite party number 2. By the order dated. Order dated 17/1/2024. After several attempts, notice could not be issued. Therefore, on 10/4/2024, the IIC Kuntuni PS was directed to serve the notice on opposite party number 2. And IIC was also directed to directed to be present in the court. On 8/10/2024, the IIC appeared before this court and informed that he has served the opposite party number 2, and the opposite party number 2 has requested him to seek an adjournment. Accordingly, the matter was adjourned for today, with a peremptory order that the matter shall not be adjourned further. Non-appeals for opposite party number 2. Next paragraph. At the instance of opposite party number 2, FIR number so and so under section so and so came to be registered against the petitioner. The petitioners. The allegation in the FIR is so and so. You are the petition number 1 is the husband.
No, so these are the in-laws, you will say.
Who is the husband?
Husband is not here. Husband is not here.
He's not an accused also.
No, he is an accused, but not filed before it. No, pass.
When will you file?
Next time I'll file. All other in-laws are there, you will also file. Let it be passed.
You better file it and I release it next week. So that both all the because see the accused persons are also not there today.
No.
That's another problem. So better that you file it. Let them come to in a VC, then I'll cause that case.
I have to file another cases here.
Obviously.
So her husband and other in-laws are there also. 5 to 6 other in-laws.
Or you can move an application for including them as a co-petitioners in this petition.
Yes, I'll file a petition to implement
petitioners. That's also can be done.
Yes.
Not sure, but non-appeals for this. At this stage, counsel for the petitioner submits that the present petition is filed by the in-laws. And there are other accused persons, namely the husband of the opposite party number 2, and other those who have been implicated as Ered is an accused. Ered is accused. He seeks 1 week time to file appropriate application to include them as co-petitioners. I'm just writing that you will move an application for including them as a co-petitioners.
Yes.
Co-petitioners.
File a fresh
petition.
Yes,
Fresh petition seeking passing of the criminal prosecution initiated against them. at the, by the OPD party number 2. Here's the matter on 4th, 6th, 6th you file 6th, before I am listing it this on 6th, you file it and mention so that on 6th both the matters will come. Okay. Okay, 6th. Yes.
46.
Yes.
It dropped in detected foreign secret manner.
Yes.
It dropped in apprehended rural Kenyan matter. The allegation is the forest staff, that is, both the cases, there are two cases, madam. First, I was submitting, there are two cases.
Yes.
One offense.
Yes.
The first offense, a job was coming in the national highway 6 and it was found loaded with generally near Governor. The forest secret, forest guard, only one Bhagirathi Nayak has seized the job and a meeting inside. And the allegation is that the driver fled away from the job. My plea before the planet airport, during plans in the forest manner that I was not there in the top, nor I am traveling in the top, that I am passing from a tire carrying shop in this Swahili shop, so I am saying that this forest people evident. Now, during that matter, can I give my relevant portion of the childhood judgment? Substituted by typing manner.
Co-accused in case of co-accused.
With observation that he is nonetheless. He is neither traveling nor he is there in the job. Now, for the first statement, he has given prosecution report in the first offense. Again, informant is in the ERTC because there is output near the first.
Which part of judgment you want to read?
You want to can see page 17 or
17.
17. What is JMFC has observed?
Yes.
Yes, according to this JMFC.
Read it. Yes.
Yes, I'm reading.
It is clearly accepted.
Yes, the testimony of Peter Ford, who was the first person who claimed to be to conduct search and seizure of the job loaded with chemicals, indicate that this accused. This accused, you are facing trial there. Was facing trial in UBC.
I know, understand. Read it.
Yes. These accused was another than the driver of the state truck. But now you usually say CORAM only this accused was present in the truck. Both were there in this place of occurrence.
On this petition, that is our ask called while disposing application. Ask the petitioner to raise all this point before.
Yes, yes, I am disposing my application.
Since there is a judicial order, there my already my order is there my order. Again,
wait, you have to answer. Sir, in that case, I have challenged the cognizance. In this case, I have challenged that I was not there. This I am not there.
This order was passed on 25/6/2019. When the judgment was passed? 2010.
I am in equitable judgment. The finding of the law, related court below, is that I am not the in the first.
Charge has been framed.
I am equitable matter. I am equitable in the first case. The paragraph where cross the prosecutor report, I am acquitted in two BCC case note 61 of 99 in the year manner.
Now, in this case, what happened? In this case, charge has been framed or not?
Not charge is not in framed manner.
So then you argue this, await the order of this.
Charge is in committed manner.
You have already got an order that has to be. Then you should challenge this order in the Supreme Court. You don't challenge. Why should I go? You came. I don't know why you come here. You can't keep on trying filing petition
The assignment change, then you file another petition, assignment change, another petition. This is our practices.
No, this is not, I am not telling here, same sir, I am not telling that.
Maybe one more extra ground.
Yes.
But the fact remains, you had, there is an order facing on the record.
But if I go and appear there will be clash of opinion. Because they have the power of the JMFT, this case is decided, I am not an accused. How can you ever case I will appear and say that, yes, I am accused?
Have you challenged this order?
That is why I have come from this, if you order that inspired, I will go, sir.
No, I'm not going to say anything. Because you have invited this order, whatever.
Once a court has same jurisdiction, the SDM having the power of JMFT, and the JMFT, Master Court also having the power of JMFT, declare me that I am not I am not the owner of the crop. The allegation is that you have formed the number plate. That is the allegation that I. Once a court holds that I am not the owner of the crop, nor I am targeting the crop of crop. Memory charge is accused. He is the owner of the crop. The London court has given a finding that if the crop may release in favor of the owner. Yes. The finding, sir.
Yes.
I am not the owner. How can I go and say that yes, I have picked from a friend in that crop?
The same thing you argued there also.
No, I am not arguing, sir. I have challenged.
Para two of the.
No, sir. In that case, I say there cannot be two cases on one. That is what it is. Here I said
you are putting it in a different regularly today. That's a different story.
Sir, when
the issue is same.
This thing was not going to put my mind on that. On that.
And tomorrow if something else will come in your mind, another petition.
No. Because if you're watching, if people also get, I don't hesitate, sir.
I'll do one thing, sir. I'll do one thing. I'll simply adjourn this matter and avail the benefit of this order. Let us see what happens. You may be exonerated. If you are exonerated, it's well and good. Otherwise, I will hear you. That's the better idea. Instead of passing some order. Otherwise, I will have to dismiss it. I'll not dismiss it. And I'll simply adjourn it. Avail the benefit of this order. Go and argue there. I'll just simply adjourn it. I'll simply adjourn it. It will not be your issue.
Sir.
What do you say? Let him
Already decided.
So that I'm not prejudicing you. I understand you are predicament. I understand. You have already thought to how to do.
Dixon has said that I am not getting, I am not the person, I am not.
I understand your entire problem. I understood, but the problem is this order.
That is.
I'll simply again it go and get avail that benefit of that order. If you are getting the complete benefit, it's all right, finish. If it doesn't happen, then we'll see.
In the gate of 74, sir, I'll go to that.
But you have what to do? You have invited. When the request adjudicates for the from the petitioner, then you organize petition. Yes. Other, if you want an order, I'll pass. Better I will still do it.
You do 47 units.
So therefore, I'm not prejudicing you. Yes.
Item 49, my lordship. I am for the opposite party, my lord.
49. Who is the petitioner?
I will understand.
Yes.
I just need 2 weeks time to file my reply, my lord.
If he doesn't have the problems,
Entry models to continue.
he will be happy. He will continue.
This is slightly more essentially civil in nature and company has not been arranged as a case. In that case, fair enough.
I think he is waiting for me to leave the office.
No.
On request.
Item 47.
Entry models to continue.
Entry want to continue.
49 months. Replay, please.
Yes.
47 units. I will take fresh notice.
47.
Return, man, notice return.
Return undelivered. Prestige, huh? Prestige. 82. 47. Yes. 50.
I did the conducting also, Kiran Kumar, brother
expert today. Inform the court.
Or there is a bereavement in the family of the 58, na?
50, yes.
There is a bereavement in the family of the counsel for the petitioner and see the accompanying seeks in agreement. Yes. Yes.
Item 8.
48. Yes, 48. Yes. 48.
Launch after launch.
After. Okay. Thank you. Yes.
Well, only piece of documents against the present petitioner is the confession of the accused that he had taken the motorcycle from the petitioner is no way connected with the offense matter.
Charge sheet filed.
Charge sheet filed, my lord.
No, Judge. Discharge application. Yes.
The accused stated that, my lord, I was, that is with me, but I cannot file because it is visible, no file number available करता.
You tell me one thing. In a murder case of 2302, you want a discharge and on the basis of filing an FIR, copy of FIR. I'll read the FIR and in 302 I will acquire the entire
problem is that
what is the problem? That problem is you.
Number register.
Why are you creating problem from me?
That is
File those documents. File these documents. Because see, this is a 302 case.
I'll file in the
File additional document.
So register available करता.
No, you type it out and file it. Then counsel for the petitioner seeks 1 week time to file additional document to substantiate his case. Let him do so within 1 week. Finish the matter after 1 week.
Next week.
And after 1 week, you file it. File all necessary document, whatever you have, you file. Yes.
19.
May I please? The petitioner is the owner of a vehicle, my lord. He was not named in the affair. Your lordship turn to page 13, my lord. One order. 1-3.
Yes.
I have filed application under section 57, my lord. And the magistrate has allowed the application. Despite that, my lord, the vehicle was not released in my favor by the police, my lord. Right? I don't know.
Yes. Are you challenging this order or if there is an order, you have to release?
Yes, my lord, the order is annexed also there. Purchase it, they got choice, no?
Basic instruction. They might have challenged this order also. Nobody knows. Do you have any instruction? Whether they
Then only what happened, my lord, when the contempt notice was issued against the inspector, my lord, he stated that one revision has been filed for the additional sessions, but no step was taken. Despite that, my lord. Only yes,
I'll simply issue notice. Let us see.
Yes.
Notice. Issue notice. Let us see if the revision is dismissed, then they have to.
Yes. Short date will be.
Short date after 2 weeks. Yeah.
Obliged.
48.
Notice should be issued by the model code and it has been also the petitioner is paying maintenance amount for 14 years to his wife. Sorry, last 22 years to his wife. Now the petitioner is about 62 years old and under treatment at AIMS, and at that time he is unable to pay the amount. So that as the petitioner is being victimized of the process of the law since the last 24 years, so file this petition to set aside all the orders of these orders, along with all the orders associated with these orders of different cases in different courts from last 24 years. Another fact is that the opposite party, that is the wife of the petitioner, is present in the house of the petitioner. And the notice which the Honorable Court has issued, that also,
where is that order dated 26/4/2023? Where is that order? Show me the order dated 26/4/2023. Here number 14. 40. 14, 14. This is the order. Yes. What happened in this order? What exactly happened? Exactly, you are not the opposite party. Are you sure that you have prepared this matter? Ready? Yeah. Okay. The opposite party, the wife of the petitioner, is staying at the house of the petitioner since last 24 years. 24 years. 24 years. Yes. And due to that dispute between them due to some extramarital affairs, so the extramarital. Okay. You are your wife. 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 And that's why the petitioner had left the house before the last 24 years. And he had been staying at 24 years. You said 24 years they have been staying together. No, not together. They're not staying last from 2000. They have been separately. Okay. And but the wife is present at the house of the petitioner from that the board who has been claiming maintenance, and the Supreme Court had ordered maintenance for to the wife, and she has been he has been paying the same to till today. But after 24 years, he's staying someone else. It is not acceptable. But at that time, when there is a dispute between the husband and wife, there is a letter came to the school of the petitioner, as the petitioner is a school teacher, and that annexer 2, page 13. 2, okay. Page 30. And also she is enjoying 4 acres land of the written this letter. It is not mentioned, but there is a picture clearly, and also the opposite party, that is the wife, admitting that in several times. This letters and this. I just seek to notice letters. And the notice has already issued, and what is service position? Delivered. Yes, and also misleading the code in the page 17. Sorry, in page 22, the loan advocate for the petitioner, that is the present operator, have you filed any matrimonial issue seeking the divorce and all? Divorce. Have you filed? Yes, sir. What happened to that? This is continuing. What is the ground? The ground is that the wife is living separately at occupying the house of the petitioner, and also enjoying 4 acres land, and mentally. What is the ground of divorce? As they are not as the matrimonial service position to CORAM. Extramarital affairs on the ground. See, this is the maintenance order, so therefore we have to hear the other side, the lady. Let us see when the service has been effected, in what manner. She is contesting your divorce petition there. No, she is appearing there. And all the cases in the beginning from 2000, when the next date of hearing before the trial court in that matter? 25th. 25, and all these case 28. 25 is for the divorce petition, and for all these cases, that is on 28 October. 3 September, no? On 3rd, one minute. Notice was issued to opposite party, by the order dated 29/1/2024. The opposite party has been served on 30th of September 2024. However, none appears for hash. Counsel for the petitioner submits that the of proceeding before the trial court is fixed on 28th October 2020. And he undertakes that he would inform the counsel appearing for the opposite party and as well as the opposite party regarding the pendency of the present matter, present matter. Then it's the petitioner may furnish may obtain the copy of this order, and share the same on the opposite party number 3 or through her counsel. Please the matter on do 2 weeks work. Copy then the copy copy downloaded copy some official. 1 minute, you need to take a downloaded copy of this order and serve on the counsel for the opposite party appearing in the trial court and give a copy to the opposite party also. Okay. Yes. Right. Yes. No.
Asking. They are asking. What happened? I'm clarifying. The case 26 set up. In fact, when the case 26 of the October manual, I think 55. Case 26. So that I'm showing to 26 manual tender lands. Case 26. Case manual of the approved. Set up 5 drafts or 4 drafts or people lands.
1, 2, 3. This is service is not complete, Mr. Sahu.
My lord, the first service is not complete, but the second service, my lord.
No, now the recent service is also not complete.
It mentioned in the noting, my lord, the AD is not written and the unserved notice also not written.
So then awaiting service needs to matter after 2 weeks awaiting service on respondent number 2 and 3. Yes.
Grateful, your Honor.
Yes.
51. Just that it's my thoughts. The lordship heard me. So for the second case, the revision 597, the state has brought notes against an order passed by London such as vigilance plots.
Yes.
Whereby plots, the London trial court found that so far there are 3 accused persons, 3 petitioners. One is the branch manager of the cooperative bank, accused number 1. The second is the legal advisor to the particular bank. The third accused is the beneficiaries. So,
that lawyer thing. Okay.
Lawyer and branch manager on the basis.
And what about the other matter?
If this case will be report.
Mr. Nayak was appearing in this case, but for some reason he is out of station right now. So appearing for LMC 132.
Everyone is in fact is not good.
No, he's very he's
which one? The first one.
That's what it's LMC 132 of 2001.
132.
That's not good.
The third matter.
So if the state case is allowed or dismissed, it has consequences. If it is allowed, all those matters go back to the London special because London special here. So for IPC matter is concerned, there are materials. So for 13(1)B is concerned, that these bank manager and the legal advisor have not taken any pecuniary advantage for themselves. Forgetting the other part of the particular statute, that not only that 13(1)B includes the persons who obtained a particular advantage for this, but also the persons notes who facilitated the third parties other persons note. That was strictly ignored notes. So this particular refusal on High Court note is absolutely unsustainable. If this case is allowed note, then all those matters will go back to the special judge notes.
But he is an advocate, whether he's
The beneficiary admittedly proctor was sanctioned, 5 lakh was given, and he defaulted on the basis of concorded documents. How? Because he gave the land records, but in the 2 particular plots, the Tahsildar clarified not, these are not genuines. On the basis of concorded documents, the loan was sanctioned. So the accused number 3 was benefited, was illegally enriched because of the coalition. The way the bank manager and the legal advisor acted in paying the notes, in collision notes, they considered these third persons to be benefited. And that particular
advocation is just giving a legal advice or action. No way was he concerned with the genuineness or authenticity of it.
that is the reason I kept rather he was asking for 1 week time. I thought you are there, so therefore I said.
Yesterday, after hearing for some time, your said similar matter is also there.
Yes, therefore.
It's coming tomorrow. So
that is the reason I kept it.
That will make the position clear. What is the real adjournment? How sir? I said, history of the case.
Yes.
History have judicial conception that this is the matter, how to deal with. Here is a case, a cooperative bank has given loan to whom? A member of the society. Beyond member, nobody can get loan from this bank.
Yes.
So when a member opted for loan, that is, the loan is termed as one particular class, which shows that for agricultural purpose, if you are interested to take a tractor loan, it will be available to you. So unless you mortgage certain property, it will not be, your loan will not be sanctioned. Besides hypothecation. So loan was offered against security. What security? That landed properties, sale deeds, ROR, everything are secured as asset. Subsequently, after purchase of the tractor, that was also hypothecated. Loan was disbursed. So question of misappropriation doesn't arise. 13 has no application so far as this particular case is concerned. No declared. 13 says criminal misconduct. If a criminal misconduct, by your criminal misconduct, you are making some advantage.
That is the reason you have been exonerated when 13(1) year. That is right, then according to you.
I have come against that judgment only because
the other penal offences are there against you.
Because he is also a magistrate. He could not deal with those matters. He is a special judge having my first class magistrate power. And these are the offences can be triable by the magistrate first class.
Yes.
When he is having that jurisdiction, what made him not to be able to discharge me?
Right.
One part is hearing, other part is exonerated. So far as 13D is concerned, all of the persons have been exonerated, including the counsel. And in the meantime, beneficiary has died. They are not thinking about that. If the beneficiary dies, what will be the effect? Effect would be from the secured asset, it will be, the money can be recovered. So whether secured asset is there or not, that is a part which is civil nature. So far as this aspect is concerned, that I have lent money or I have given opinion that you disburse money so far as the borrower's loan account is concerned, that part constitutes 2 things. One may be civil liability, one may be criminal liability. Criminal liability comes as a recent decision that it is a grave misconduct. Furnishing an opinion basing on the title deed which appears prior to see that there is a seal, government seal, everything is that has not been seized. But I appreciate Our has not been said.
You show me your opinion.
Yeah.
You show me
I'm
your opinion.
for the manager of the bank. Manager of the bank, so far as utilization of money is concerned.
Where is that opinion given by the lawyer?
Lawyer has given out where the bylaws of the society says that a borrower has to furnish application.
I understand that. Where is the opinion given by the lawyer?
Your Worship, we don't have that, we find it in,
That's the document I want to see.
there is a Worship, I currently don't have it in the file, I'll definitely
They are for the
file it in the course.
lawyer. I am for the bank manager.
That's right, but that very
Currently the file, does not have.
I can't be heard peacefully, though. She's for the lawyer.
The Worship, the lawyer was only, his work was only to the documents that was.
163.
35, which is filed by me. 160.
Worship, give me, one day, this matter will come up tomorrow, I'll file the.
Next week then. Yes, next week. Next week. Fifth, we'll do. 3 okay. Fifth. Entry mode to continue. All the matters, huh?
Yes.
There are 4 matters, huh? The lawyer is, what is his name? Hemendranath.
Sub-item 3.
Yes.
They be extended so far as the.
Yes, this will continue. Entry mode to continue. Yes. Next. Because of this item 52, I have asked the UA matter to be listed. Because the same thing he is arguing.
That's what your Worship was opening is.
He's arguing.
Okay, if it is to be argued that matter, correct matter, I am.
No, let us see. They have to answer it. He is already argued. Yes.
So this is not the case. My finger was arguing that the your Worship was
last judgment. Full judgment he has relied.
Yes.
He is covered by the last judgment.
Yes, but it is not coming to under the because they are the panel layer. But we are doing the let's see. But we contact the purity of the
the way he wants to.
The bank has engaged him. Maybe he may not be out of
Last judgment.
I just see.
Last judgment mandatory condition.
Yes.
And implement they are lawyers.
Yes.
It may be the rapid worship, not that for this purpose only he has been appointed.
Now, what do you say? Yes.
Let me see that why the one by one union. That is the record is not with in their name. Land is not with their name, Lordship. But loan has been sanctioned.
Where is that opinion?
It is there. The opinion there also. I am married with trademark. And I last portion of the file. Last portion. Opinion I have written also. Lawyer opinion.
No, these are statements, sir.
Very legal opinion. Yellow marking you see.
Yellow? It is there in this record.
What opinion are given? Opinions are in this aspect. All the opinions are one.
And your record is not
How many opinion you have given?
12 opinion is
12.
12. Yes.
My lawyer wants to discuss the ground that all the reported cases.
Reported cases, I am not going to judgment mercy. I am not how bracket and this
That is an admitted position. He has given a misleading opinion on the basis of which loan is sanctioned.
Yes.
That's there. I'm not disputing. That's right. That is admitted position.
Yes.
I am not disputing that. Now the question is, he is relying upon a judgment saying that if an opinion given by a lawyer,
that is the panel lawyer. That is in that I will do also. Yeah, the panel lawyer.
Can I give a report without any?
Bank is not against.
No, from the bank in general, say if it is sanctioned to the from the lawyers, then only that
bank can engage beyond penalty for bank can engage.
this person because we can against the criminal.
Let us see.
Yes. Where is the panel? Para 6 of the judgment lordship, where is panel there? Now counsel for the fixed subject. Practicing advocate and the panel there.
He say that without authority, he will give a report on
This purpose only.
This is what is who will give given that appointment? Appointment has been given by the branch manager.
That is the question.
I don't know whether it has been approved by the regional manager or
That was not approved. So that means
responsible for that.
If I may, show me the opinion. Where is the opinion? This is an address to advocate or something.
I have given the opinions, that all the opinions are in this line, madam. Referring original record of rights, bearing
things there.
You show me the letter dated 13 to 2012.
13 to
2012.
13 to 2012.
See, in the opinion at the top you have written, see, his argument is what? His argument will be taken care of if you show me the letter dated 13 to 2012.
My lord, with reference to your letter number 14/3
it addressed to whom? Just see.
to the branch manager,
Then the branch manager might have requested you to give an opinion. That request letter is 13 to 2012.
that request letter is 14/3/2012.
No, with reference to your letter. Dated 13 to 2012.
All the opinions are of the.
And the subject is share with this opinion.
My lord, yes.
So therefore, he might have requested you.
I am not on that.
It's not to be relied upon. Not to be relied upon. How will you implement?
What is the opinion, lordship?
Error of judgment. Error of judgment.
Lordship, no, I am not on that. I am not on the error of judgment. I am on the how a lawyer is giving an opinion. He will see the genuineness of all the documents. Then he will give the genuine.
That position is covered by the judgment. Have you read the judgment?
Yes,
This is not a judgment.
The panel law. Lordship,
Don't read panel law. See, if the branch manager is requesting.
this is only meant to make the illegal.
Show me the letter dated 13 to 2012. That is the request by the bank to the lawyer to give opinion.
Different letters, my lord.
One letter you show me.
Yes.
That effect also, Ajay Kumar Ratnath has given and another lawyer has given the opinion that all these things are fraud and there is a letter that.
Affidavit it was empty. Good lawyer have it on it.
13 lordship. That means public money will go in this in such a way because he is a
Okay. This is one of, may kindly see one of the letters forwarded to me, but no date is there. It's the format, I think. I will collect it, Ballot may kindly see that.
Yes.
Similar letters must have been issued. They must have seized the letters during investigation.
Yes, it is there. All these opinion letters of the advocate.
Not opinion letters, letters forwarding the documents to the council. That you have to show.
Will you read the opinion? Will you read the opinion? You got the opinion?
Yes.
Read it.
Original record of the
And read which is this letter.
Yes.
This letter, bank has written a letter to the lawyer saying that we are enclosing this document. The document lists are there.
Yes.
And verify it and tell.
Yes.
These are who is supplied the document? Bank has supplied the document
Yes.
to the lawyer. And in the light of that letter, now read the opinion. I'll read the opinion.
Yes.
Opinion it says.
Letter 13th and
No, para 5. These are para opinion. Right now.
para 5 discuss.
The encumbrance certificate as produced before me.
Yes.
Who produced? You produced. The bank produced. From 1st January 1987 to 13th February 2012. Against Hull Khata number so and so for a period of 25 years. It go to show that the applicant is in physical possession over the aforesaid land along with his own right. The title of the land described above rightly with the applicant and therefore he is rightful owner of the said land. This is the opinion rendered by the lawyer on the basis of documents supplied by the bank.
Then what is the duty to see the veracity of the
Now read the judgment now. Yes. Judgment of this court.
I am also the description of the property to be encumbrance in the what is
Now read the judgment of the High Court. Read judgment of the Judgment of the High Court, that is the criminal revision 229 of 2020.
Yes, sir.
But very exhaustive judgment. Read the para 3.
With regards to practicing line of attack.
Para 3. He was also a lawyer.
Yes.
Submitting a document in respect of the property offered as a collateral security by whom? And the
Documents with that person's name.
you read the facts of the
Lots of the fact of the case should be also taken care into. Suppose a land is not in that person's name, but he is giving the opinion that all these documents is correct, genuine. Then what is the duty of
The lawyer will go and verify the law.
that is there verifying?
No. No. Papa, you have a field officer.
They are giving their
Every bank has a field officer to go and check. Lawyer will add up in the document supplied. He will not go to verify.
Some other day I will do the deal.
Sir, if you want an evidence, you to believe what the document. Suppose somebody comes and gives an avocado now. I'm saying that I'm so and so. What the best he can do is, you cannot very well ask you, show me your Aadhaar card. And we don't do that also.
Let me sellers.
You believe what the lawyer document has supplied to correct?
Lawyers when they are writing that the original document is a such and such. Suppose they are searching for the 2000. They are also putting a column. Then some of the document
Aspects quote in the judgment Malak K. Narayan Rao versus CBI has categorically observed it is not the duty of the lawyer to verify the genuineness, to investigate into the genuineness of the document.
That's the judgment. That's so difficult. They use apply.
Paragraph 22, 23.
You see, in this letter, you have written.
I understand. Data is given on these letters. Therefore, public money will be given by this process.
But public money is not taken by nobody might have paid or might not have paid.
Not that. This is the after data evidence come out, all this money has been by for example, why
You don't argue general points. General point everybody knows. The lawyer might be involved. I am not interested. Maybe involved, he might have taken the money. I am not interested. As a law point, if these are the facts, how will you deal with this judgment? He is directly covered by the judgment, wrong, right, whatever. What to do? He is a bad man. What to do? So he indirectly will say that this way we could do. No, he will say everything on directly only, on the basis of judgment. No indirectly. You know, what to do? What to do? The judgments are such. But that way I am saying there, his opinion I am saying. Each and every opinion.
Sir, lawyers are associated with banks, they also render opinion. Opinion on the basis of the documents sent. Documents sent are on the interest, see everything. Basing upon that, we deal with the case and give our opinion. And these are the documents from which I can opine that a title flows. That is the only duty. It is not that we will go to certain offices, verify those documents, whether the title deed is correct or not.
It's not possible. It's not possible.
That was the exact language. It was not possible on the part of the lawyer to investigate into the genuineness of the document.
Even if it is possible, what should the lawyer do?
What should he? Yes.
Even if it is possible, even if it is get back into your house, where should you go?
Court छड़ी की जाएगी बुली होती है. Verify करो इससे.
I tell you, I have my personal experience. One of my friends, who is a very seasoned lawyer, he is the P junior. The board junior says that, sir, हमारे पास तो केस वेस नहीं है, कोई पैनल में हमारा हो जाएगा, आपका नाम पे करा दें. तो बोला करा लो, क्या दिक्कत है यार, तू 2 पैसा मिलेगा तो ठीक है. Panel lawyer, my friend, and they did all this thing, and a criminal case filed against him. Every year, his name, even he was not signed, DDS have signed. He faced it, ultimately he got it passed. That's a different story, but this happens. What to do?
One part of time, almost all my contemporaries, classmates, they are big stars in different banks. They said, why you are not taking our bank cases? I said, give everything, but don't do that. Like good friends, but don't entrust me bank cases.
Will you verify each and everything and you want little time, then I'll put it. The other matter I put it on 5th, I'll put it on 5th. Sir's matter also I kept it on 5th. Don't argue general thing. General we know what is happening. How will you deal? On the facts of this case, he is directly covered by the judgment of Supreme Court as well as our own High Court by Justice Ortho's judgment.
And all the judgments are of lawyers.
All the lawyers' judgment. You prepare the chart and whatever you want to say. Let him get an opportunity. He should do it. And I only request, in so far as the 12 cases are concerned, the opinion and corresponding letter, because I have to represent that. So that it will be easier. And give a copy to them.
On the 5th, that will be taken up.
3 o'clock. 3 o'clock. 3 o'clock. Okay. Yes. 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 Let him come. Next call.
56.
Nobody is here.
56.
No, we have taken 50.
52.
53.
53 already. 55 also.
54.
54 at 3:30.
3:30.
For
55.
56.
56. Yes.
Item 56, you will also remember, supposed to quash the entire proceeding. The son has initiated a criminal proceeding against the mother, who is 85 years old, my lord. The cognizance has been taken. This arises out from a civil dispute, my lord. On the basis of a complaint case, affair has been registered. Cognizance has been taken.
You are the mother.
I am for the mother, my lord. And in other than Mr. Jan.
And complainant is the son.
What?
Complainant is son. One. Because he has the problem with another brother.
He has got the cognizance, he has not filed any case against another brother, but has filed a case against her own mother. And the immediate filed a suit also. Mr. Janaki also.
Mother is being prosecuted by the son. Mother is 82 years old.
Okay, but I am not in that particular scene, but civil son has been forged.
Forged, the other brother, see, both the brothers are fighting for property, using mother.
That compromise, last time compromise.
He didn't come forward.
And he is not interested to compromise.
Your lordship are supposed to call.
The mother, they using mother for settling the property.
But document,
These two brothers.
but document from RFC and SNS
He had already taken his share way back in 1995, and you also kindly see.
I know there is a problem between you and your brother. Sorry,
He's not.
party number 2 and the brother. You are for the mother.
I am for the mother. It's not a party in the proceeding.
Where is the other lawyer?
He took twice time, my lord.
Let the interim order continue. None appears for opposite party number 2.
At least and before the death of the second.
He doesn't come, enjoy nothing.
In self-serve ground, the civil suit is pending. This proceeding is not at all.
I stayed the entire proceeding.
You will also stay the proceeding, but the proceeding has to be called on the basis of a civil proceeding has been initiated for the self-serve property.
That's right, let them come.
And the civil suit.
None appears for opposite party number 2 despite second call. In the interest of justice, I can to so and so interim order to continue. It is made clear that no further adjournments are granted. No further adjournments are granted. Yes. They do down the adjournments.
Okay, sir. Item 7, I am for the opposite part number 2, my lord.
Yes.
So, lodgement direct to the petitioner to short copy and
Change of lawyer. I don't mind serving the copy. It is a change of lawyer. Every time the case is taken up, there's change of lawyer. But with due respect, I'll serve a copy. You should have told me earlier.
No, he has been waiting since morning.
મને હું સર પટેલ બાલેશ્વર બાલેશ્વર વકીલ સર અત્યારે પૂછલે ના પટેલ કે આપણે કોઈ સર કાલી દે દેવી.
Do you give a copy?
Yes.
And I list it next week or sometime. Monday to Tuesday तक बताओ जरा देखिए. Half 7. Weekly. Monday.
Sir, entry model to one.
Entry model.
59.
Yes.
May I please? Here this matter relating to the passing of the proceeding under section 138 of the NI Act.
Yes. He is waiting for the other side. Opposite side.
Opening to opposite 2, my lord.
Here, I have questioned the maintainability of the proceeding under section 138 NI Act on the ground number 1. Ground number 1 is that there was no legal enforceable debt. Number 2 is there was no order of provisions. Simply directly someone has been issued. And the delay was condoned behind the back of the present petition. All these 3 points are there. So I think if I can convince your lordship with regard to legal enforceable debt, then the other points may not be necessary.
What is that?
I am referring to the allegation made in the complaint by the complainant.
Yes.
Because I know that in respect of legal enforceable debt, I need to, the accused may require to lead evidence in course of the trial. That your lordship, that
139 presumption, you have to do.
Exactly that.
Rebuttable presumption, you have to go.
Exactly. But where the complainant's pleading itself shows that the debt is not, there is no debt in the eye of law. I can say that there is no debt in the eye. That is why I am referring to the allegation made in the complaint that pays 70.
What is your name? Name is Konaklita.
Anupama Vishwa.
Oh, this is the case where your son has taken money.
Yes.
Oh,
Yes, that is the case.
All right. So again,
Other point, I must, on that I do not give a answer.
Your son has taken money to give admission.
Yes.
MBBS course.
And the son is not the employee of a joint entrance.
Whatever that one. He is done fraud.
Yes.
And when these people came and started asking the money, you are the check.
Yes.
Yes.
And there
Which is designer.
Which is designer.
Yes.
And thereafter the also lost. After 1 month, the FR was lost. I am not going to that FR.
That FR is pending.
FR is pending. In connection with that FR, the present petition was.
Why it is not legally recoverable?
Because the purpose for which she had made the payment. That is the base of the record, and I got.
What is the reply you have given? Are you denying that you have rechecked?
I do admit that.
But you have issued recheck. The test according to me, subject to your correction. Test is, if a suit under order 37 is maintainable, then it is legally recoverable.
To that effect, I am relying upon two, three.
Whether a suit could be filed for recovery?
No.
Right.
There is no contact. Because
it is not required. It is, you admit that I have, my son has taken money, so therefore take the check.
No.
So the admission on your part.
My son has taken the money.
Therefore you have given the check. That's the case. That is your admission. That is your admission.
After they started the processing of coercing measure with regard.
Admitting that my son has wrongly taken money,
yes,
and I am discharging that liability.
Yes.
So therefore, this is an admitted liability.
Yes.
Now the question is, the expression used in 138 is legally recoverable or not?
Yes.
If a suit could be maintained under order 37, then it is legally recoverable.
But here the question is that
can he maintain a suit or not?
No.
Satisfying. According to prima facie view, a suit can be maintained. For
that purpose, I must take your lawsuit to the law of contract. Section 23 of
for order 37 suit, contract is not required. You are the contractor. So,
Madam, there is a question of recovery from which she wants the recovery from the petitioner.
Is a recoverable amount from your son, which liability you have taken over and given?
Legally recovered. That is why your lawsuit on 5th of August formulated also 2 points. That one thing is he has to show that that was legally enforceable, and another.
Do you have any judgment? My lord. Yes, my lord. You don't give general answers. I don't have time to unnecessarily this thing. I'm asking a straightforward question. Can you maintain a suit under order 37 in this given circumstances? See, if a check is issued, you can, if it is dishonored, you can very well file a 138 proceeding, no doubt about it. And along with that, you can file also a suit for recovery. Both the things are maintainable. Order under order 37. Can you maintain a suit in these circumstances on the facts of the case? If you can maintain, then it is recoverable, legally recoverable. Do you have anything? No. See, you are holding a difficult brief, you must prepare in that level. Level of preparation has to be there.
But I am referring to the latest judgment.
Every time I adjourn the matter, he comes with one judgment.
No, not with one. I have got 7 to 8 judgments.
And he accumulated 7 judgments in his favor.
We should have at least one. Because I have 3 points. All points I must be supported with some judgments. And my first point that
legally recoverable part may be debatable, subject to what he says.
Right. That has been squarely covered. My ground is squarely covered by the decisions rendered by the Honorable.
He has not prepared, let him prepare. Simply adjourn to after 2 weeks, interim order to continue. You prepare and come. It is very serious issue that he is raising. And all the 3 points you understood? And prepare and come.
My lord, may I tell one thing? You also adjourn it. I don't mind. If my learned friend could have asked the time, I don't have also any objection. May I request your lordship to submit the form? And this
It's already there. The moment I introduce, already there. Don't worry. Don't worry. I know these are different.
Can I make a request for taking up the matter?
So
At 3 o'clock?
How, give a date.
Any date at 3.
In the facts are so fascinating, I'll never forget.
Actually, I was done it by the least.
So, see, that's the difficulty with senior counsel. I was 3 o'clock something. But keep it calm in that level, I think. Please give the judgment which you have 5, 6 judgment to copy of this.
Yes, sir.
You will prepare at least.
Yes, I'm giving it. I'm giving it just order. अरे भाई चलो कोर्ट वालों चलो उनके कोर्ट समझते हैं
So the judgment read it and try to do it.
बाकी 3 टाइम को उसमें गवर्नमेंट को तो मातुरिन को
Yes. Yes, Mr. Palik. What is this matter?
A short list of dates. Then actually kindly.
What are you asking?
Now I'm asking for quashing of the proceeding. Under 376, it's A3.
What did we say?
Good enough for the intended. Absolutely right. All the bogus affair.
No, investigation charge sheet has been filed.
Charge sheet has been filed.
Yes.
It's a manifestly attended with nullified. The 7th ground of Bhajan Law squarely fits the facts of this case.
Yes.
IIC list of data. List of data. Oh, private opposite.
Mr. Rahul, are you ready? In between, don't ask time.
Well, my lord, only I can help you, my lord, to read out the 164 statement, which is in the closed envelope.
Facts are just, Lordship, published in 2 minutes. I acknowledge, of course. I can't, if my lord is free. And the IIC.
Just run through.
No.
Run through. Let us
give a brief overview of the facts, my lords. And the IIC of Thana, my lords. And this complainant is a sub-inspector working under NIGA.
Okay.
Now, he was a habitual manners mischief monger. She raised ruckus with everybody in the Thana. There were several complaints against her. There was nothing called being of discipline in her conduct.
What are the nature of complaints against her?
So the
kind of
she already worked as facility.
Insubordination kind of things. Yes.
The whole lot.
Hmm.
The whole laundry list is there, including absenteeism, unauthorized absenteeism. She had been sent to Cuttack for a puja duty. She never reported that. Never bothered to report that. She will come in the Thana, sit with her legs up on the table, not attend telephone calls, not attend to the grievances of persons who have come to lodge an FIR.
Yes.
Always speaking on the mobile, talking in a loud voice. All these are all manners besides the point now. They would be indicators for her behavior. Now, I gave her a report of average. And I also mentioned in our CCR, she was held up for habitual absenteeism, unauthorized absence. The department, she alleged that I had some relationships with some lady constable or whoever, whatever. It was inquired into as a DSP. DSP report is Kathy, but she's in a habit of raising these false complaints and in a habit of maligning people. The DSP report is Kathy. And all the officers have given, Thana staff have given, evidence in my favor. Then she raises, once you are on the verge of.
That was the Vishaka complaint.
Harassment of women in the workplace.
Yes, Vishaka.
Vishaka.
Yes.
Vishaka complaint. In the Vishaka, she was unable to prove the case.
Yes.
And when it was about to, the report was about to be filed, she comes to the second complaint after like 3-4 months. 354 she was unable to prove. He says, I've been raped.
Subsequent to the earlier one.
Subsequent to the one.
Yes.
Rape, that was 2 years, some odd months ago. 2.5 years ago. 2 years, 5 months ago, I was raped. And
who was the complaint in the first one? Senior complaint.
Senior only complaint.
And if she could have complained, saying that this gentleman has raped XYZ, he could have done that also against her if anything had happened earlier. She could have done it.
Sub-inspector, she was lodged a FIR about allegation of rape 2 years, 5 months after. And on the day, incidentally, knowledge how false it is. The date of incident she alleges, she on 23/5 or 24/5, 2015.
Yes.
I was raped by the IIC. I came to the Thana and asked the IIC that why are you, how could you do this to me? He said, IIC said, make you.
How are you do? You are request there was no request from here. I was somewhere now. He is saying something. Well, are you saying about some cases? I'm not about that matter. That is very important. You forget about the matter. I don't know. It was very dicey situation. So we are also trying to get
Lordship says correctly, if this side also very danger, that side also very danger.
So let's see. Alija, watch Kariki, she can take a call tomorrow.
I think for tomorrow till afternoon we can work safely. Yeah, we can work safely. Thereafter maybe little quality. Maybe.
Difficult to come actually. I don't
dangerous. You don't know. Once you come, you get stuck.
Already, the bar chairman and
Adjustment
accommodation, chairman, president of bar association, and also chairman of bar council. They made the honorable suggestion. So to pass any council not appear.
No advance order if the judges can come to the court. And you will safely stay home saying that no advance order in fact, judges to come and hold the court.
We've seen 99 minutes, it was horrible.
Very dangerous. You never know, you can't
dangerous and horrible. 99 we have seen.
I think things will be. And which date you want?
Any date convenient to a lordship.
I'm here only convenient to which night you will take.
I said, all the light there, but nice signal is that I was supposed to put the logo for it again.
Which day will be convenient?
Next Friday?
Next Friday will be booked.
Holiday.
Let it be on 8th Friday.
8th Friday.
I have a small request.
Let me
remember that I have a group of students. They were initiating before the Board of Secondary Education about this Vidyarthi Parishad students, students, and out of which some people are getting job there because of the tendency of the criminal case, they are not getting. One case was filed, thereafter another group of students were filed, both the cases are annually come listed to my lord.
What are the offenses?
Madam, offenses enslaved along with Schedule 7 that were given. The president who lodged the affair, she defeated the court before this rule that one minor she said that I don't know anything, particularly
word is used. So what my Lord said, the last occasion my Lord says, you are not in this court, you are in the court of the prosecutor. You tell the prosecutor, the prosecutor will say, yes, see, why don't you? They are young people. In the college they resorted to some strike and all.
In fact,
Young students. Students of 2 lines I'm reading. And from my office room, which situated at first floor, the gate of the office was not visible. Then it is not a fact that the news of incident took place and no one sustained any injuries. See, herself even because who says that? But the president himself, the president who is implementing this case, since given this depiction before me. That part, all are young students. Yes. Young students. Damn thing happened. Why to spoil their career? It's not unnecessary. You give written submission, I will pass you. Online written submission. Yes. Highlighting this thing. My lord. Please clear for the procedures. I think 54. Mr. He is asking for stay further questions. Why do we have it?
Nothing has happened till date.
The case is pending. Let it be stayed aggravate. Why to aggravate things? I understand. If still, if you want to settle the issue, just settle the mind. I can go but the night one of the colleagues चलो तब तक हो माने देगा people for granted this court for granted but this is the attitude of the this is the order of the meditation mother. So meditation but this one also is not innocent. Both of you are all the police officers. This 376 of the assuming. This is my last and this is what he is avoiding the postal file. If everything is into another city, can we stay for the project? My lord is fixing any date or any link or I will fix a date for formal hearing, but come with the written submission and
Item 61. It's a very common matter. I can pick one.
Stay, my lord. May I pay can you repeat the
Item 61.
Any day you are
29th. Okay. Because I'm coming on that date. That's only required.
Okay, 30th. He is coming there on 30th. 61, 30th. Entry mode to correct.
Item 66 for hearing. The paperwork has been sent to this honorable court without verification. My prayer before your lordship that let registry verify the paperwork is still you are stuck in the paperwork business. It has been written. Forget it, you are moving from here. Why are we stuck in paperwork? Anyway, take copy of paperwork thing.
Directed to supply the copy of paperwork to both the counsel appealing for the petitioner as well as the appellant as well as the business. These matter in the weekly.
This is to verify whether it is in order.
What is not verify? Don't increase their work.
It is without verify.
I will verify here.
Okay.
I will verify. Don't worry. Not verify. Don't worry. Pardon.
Item 61 at 38. Can it be 2 o'clock, my lord? Because
for last occasion, some of your junior, I'll take it 2 o'clock. No problem. Don't worry. Pardon. Item 60, my lord. Can you take me 1 week after? Entry model is there, my lord. 60. 60, my lord. Okay. Urgent. Continue 2 weeks after court.
Item suspect entry model of their lordship.
62.
Entry model adjournment.
Yes, Lordship. Same.
Ballot item 62, my lord, I'm through VC, my lord. Ballot item 62, your lordship, I kindly call it with CRLMC 2030 of 2024. In 2030-2024, that order has been right now being conducted at 4 p.m. So, my lord, the mediation is ongoing. So, therefore, I would request your lordship to...
This is connected to this matter.
Yes, your lordship. My lord, in CRLMC 2030 of 2024, by order dated 24/7/2024.
At least, item 62, no?
Item 62.
At least the matter along with
CRLMC number 2030 of 2024, your lordship.
After 3 weeks, huh? Mediation, in that matter, mediation is going on. You want to continue. Yes.
Grateful, your lordship.
Yes. Thank you.